have received apology from Senator Natalie Campbell Rodriguez, Senator Scott Motley, and Member Delroy Chuck. I think Member Chuck has indicated that he may join us online as he is out in another parish attending some matters within his portfolio. Any other apology? Right, there being no other apology, we will proceed on to the next agenda item. Let me take this opportunity to welcome all committee members and to thank those who are present in person here in the chambers and those who have joined online. Although the meeting is being convened in hybrid form, I've indicated that the preference is for members to be present in the chambers. I do understand that some members have challenges and really want to attend and therefore take advantage of the technology. I understand that, but for others who can be present in person, I ask as far as possible that you come in the chambers, particularly when we are receiving presentations. I think between last meeting and now, a lot has happened. A lot of discussion has been generated on aspects of the bill. And I thought I would just use the opportunity to just speak to something that is being discussed in the public sphere on the matter of pre-charge detention. Clause 5 of this bill, entitled the Bail Act 2022, sets out a scheme in respect of grant of bail prior to charge. And just to make it abundantly clear that what is contained here is premised on there being detention of persons before a charge is made. So just to say that it appears that some questions have arisen as to whether there has been proposal in respect of targeting offenders and also providing for serious offenders before the police are able to charge them when they have reason to suspect that these persons have committed offenses. I had pointed out previously that our Constitution at Section 14 makes it clear that a person may be detained or arrested and therefore deprived of his or her liberty in circumstances where there are grounds for suspecting that the person has committed an offense, and also on the second limb where it is reasonably necessary to prevent the person from committing an offense. As we put a suite of legislation together to address the crime problem, we have innovated, looking at where the boundaries are, but also to target in an unprecedented way those offenders that are wreaking havoc in our society. And the provision in respect of pre-charge bail sets out one aspect of the targeting intervention. The flip side of it is to be set out clearly in the other piece of legislation that is to follow. I just thought it important to point it out to those who are listening. You may recall that when we met on the previous occasion, I indicated that I anticipated that the pre-charge bail provision at Clause 5 would generate much interest among those who are seeking to comment on the bail bill. You will hear more about the entire scheme in respect of pre-charge detention and the grant of bail pre-charge, and also dealing with offenders where the police need time to build out a case against them. Right? With those brief opening remarks, we will move to the next agenda item of the confirmation of the minutes of the meeting held on November 3, 2020. The minutes were circulated. They are 4 short pages. We can take them as read if everyone has read the minutes. In respect of page 1, which sets out those in attendance, in person and virtually, those who were absent, calling to order the prayer, apologies, and welcome. Is there any correction to that page? If there is no correction, we can move to confirm page 1 of the minutes. Page 2 deals with new business, procedural matters, decisions taken by the committee in respect of chairmanship, quorum, submissions on the bill. Any correction? If none, can we move to confirm page 2? Yes. Moving to page 3, public education campaign, meeting dates, information on the bill, and other matters discussed. Any correction? If none, we will move. And then on page 4, carrying over the matters discussed, any other business, the date and next meeting, and the adjournment. Member Paulwell, move for confirmation. Seconded by Member Charles. All right. In the past, it has not been the norm to share the clause by clause. It's usually done when the debate is commenced, but I believe it is useful for all members considering to receive an indication as to the policy intent behind the provisions. And it was that in mind that the commitment. Any other matter arising? All right, then we will move to the new business of presentations, and I'm advised that School and Jamaica for Justice are both present. They have submitted their presentation. So we will invite them in the order listed on the agenda. We will invite the presenter from the Norman Manley Law School. And just to say that we will listen to the presentation, ask questions to clarify, but at a later stage we will then, when we come to deliberate, we will consider the submissions made in respect of the clauses.
If it pleases you, Madam Chair.
The Norman Manley Law School is joining virtually? Very well.
Yes, Madam Minister. I was given that option, so I scampered and took it.
Welcome, Ms. Kohler.
Thank you, Minister.
Yes, welcome. We look forward to the presentation. Thank you for accepting the invitation and also for providing the paper.
Well, it is us. Well, I certainly have the duty on behalf of Principal Aina and the law school to extend our gratitude for being invited to make submissions on this important piece of legislation. And we hope that our contributions will serve a useful purpose. Now, as you have rightly said, Minister, the submissions are for the most part in writing. And I say for the most part because since handing them in, I have discovered other things that should be included. But I'm also aware that the time for presentation is limited. And I'm just prepared to begin, and wherever the chair believes it is convenient to stop me, then that is fine, because as I've said, for the most part, it is written down, and if you wish, then the changes that are to be made can also be included in a later submission and sent to you. Okay, so I'm going to follow the submission as per the written document for ease of reference. So the general submissions of the law school are broken down into three parts. One, we're looking at the constitutional soundness of the bill. Then we look at the implementation and the different schemata of the provisions under the bill. And then in section C, there's a general trawling through the bill. I will focus more so on A and B. Now, we're making an argument in the alternative. And the general submission really is that there are portions of the bill that are likely to be found in contravention of the Constitution, in particular the Charter of Fundamental Rights and Freedom. In either that there is no power to legislate certain provisions in the way they have been legislated, or in the alternative, if the power does exist, then the way in which it has been exercised in the bill contravenes or is likely to contravene the Charter. And it is submitted in particular that the bill is likely to be found in violation of inter alia sections 13 and 14 of the Charter. There are other considerations, as you'll see in the footnote, other sections of the Charter, sections under section 16, for example, that may very well be implicated as an unlawful encroachment because the provisions in question cannot be shown to be demonstrably justified in a free and democratic society, as our courts have interpreted that section to mean, or that provision to mean. And furthermore, even when one may arguably succeed in showing that indeed that there are pressing and substantial objectives that need to be met, and that is what the bill is attempting to do, and perhaps furthermore that those objectives are rationally connected to the resulting restrictions, it becomes more difficult to demonstrate that the impairment of the rights affected are minimal as are required under the test, or furthermore that there is proportionality between the benefits gained and the negative effects that these provisions.
Could I just raise a point of order, because I am not hearing well.
All right, just a minute. Yes, we're having a little bit of difficulty.
Yes.
Hearing clearly. I think we're competing with the air condition unit or something in the chambers.
I see. I wonder if I use my headphones here, it would make any difference. I could try.
They were testing the sound earlier and it was perfect. So
we're hearing fine online, so I think it's more likely something in the chamber.
Oh, okay.
Is the earphones, are they helping?
Those of us who are online were hearing you fine before, and we're still hearing you.
Okay, thank you, Minister. Okay, so I see what you mean. The problem is not from my side, so there's nothing I can do. I take the point. But nonetheless, members in the House, is it any better with the headphones, or it's not?
I think we just have to listen very carefully and keenly.
Very well. In any event, for the most part, it is there in writing. Well, let me take this off then. Required. Where was I? Okay. I'm at 1.41. That is where I pause. We're saying that secondly, this schemata, the schema firstly created for the treatment of persons arrested or detained for an offense for which they have not been charged because of an insufficiency of evidence undermines the constitutionality of the provisions. And I should perhaps add here that on a second, or rather a multi-look at section 7.2 also that deals with the post-charge defendant, that we also take issue with the constitutional, a more nuanced issue as than stated in the submissions, with the constitutionality of that provision. And of course, I'm in total awe of the workmanship of the draftsman in creating an intricately interwoven act. But it did make the work of attempting to understand it, interpret it, and determining what section applies to what more difficult. It is true, it is new, and everything, and new things take time. But indeed, it seemed a little bit more than just its newness that created that difficulty. Now, we're all familiar with the provisions of the Constitution, so I won't necessarily go into them. They're contained there. We're saying that liberty is the charter rights that are implicated. First, liberty, and especially liberty in the context that section 14.1 says, lays down a three-pronged test that the liberty of the subject can be encroached upon. It must be on reasonable grounds, that is the first one. It must be in accordance with fair procedures, the second one. And the third one, that those procedures must be established by law. And we find that all three of these are implicated in their provisions. And we have here the right to freedom of movement, equality before the law, the right to freedom as provided in section 14. There's also issues of due process, equality of arms, right to counsel. All of those issues also arise. Yes. And of course, all of this is against the background, as I've said, of how the court had in Adrian Nation and Karine Wright, as well as in Julian Robinson, have contextualized the work of the legislators as against the work of the court, and therefore the interpretation of the Constitution. And just to look at section 2.3 in the quotation, it says that in deciding whether any provisions of a law passed by the Parliament of Jamaica as an ordinary law are inconsistent with the Constitution of Jamaica, neither the courts of Jamaica nor their lordship's board are concerned with the propriety or expediency of the law impugned. They are concerned solely with whether those provisions, however reasonable they may be, however expedient they may be, are of such a character that they conflict with an entrenched provision of the Constitution, and so can be validly passed only after the Constitution has been amended. Further, from Julian Robinson, we're reminded that the Constitution of Jamaica is premised on the notion that free men in a democracy provide the best arrangement to secure a peaceful, stable, and productive society. The separation of powers is intended to present a concentration of powers which can militate against democracy. And the guarantee of individual rights is intended to prevent erosion of the freedoms enjoyed by free men in a democracy. So bearing that in mind, and when we go over to 2.5, we take the first argument being that there is no power under the Constitution to legislate the pre-charge defendant that has been legislated by this bill. And what do we mean by that? We have recently amended our Constitution, and that amendment excluded contemplation and protection of the pre-charge defendant as legislated. And the submission is that that speaks volumes as to the value that we're placing on liberty and the other rights that are implicated. And we're not saying that under the present provisions or under the law in general, there's no recognition that in the process of investigation or administration, when someone is arrested, that there is not some time that will pass, yes, and that is not provided for in the law. But when we look at this particular pre-charge defendant, where there's an absence of an entitlement for him, where there's no presumption of innocence because he's not charged, when we look at the majority of the provisions under Section 14, Section 13, Section 16, that speaks to an accused person before the court, he is entirely excluded. And so the question does arise as to whether or not properly, on the provisions as they are, this type of pre-charge defendant can be legislated. That is the first thing.
May I just ask you, Ms. Kohler, whether we can agree in principle that that which is expressly provided for by the Constitution cannot be held to be unconstitutional. In other words, if the Constitution expressly provides for something, it is not open to us to say that that is unconstitutional. Would you agree in principle with that statement?
As you have framed it, Minister, I don't think I can take objections to it.
Right. All right. So we can agree in principle that that which is expressly provided for by the Constitution cannot be held to be unconstitutional as a matter of principle. Principled statement. All right. Would we agree that guidance has been provided by our highest court to the Privy Council in numerous cases, including one called Madehu against the Attorney General of Mauritius, which gives some advice about the approach to be taken in interpreting rights provision of a constitution. And essentially the principle is that these provisions are not to be interpreted in a literalistic way. You're familiar with that authority?
Well, I'm waiting really on the argument that you're building from it, Minister.
I'm speaking in
Chairman,
principle.
on a point of order, yes. Please. I think we were getting into the meat of the matter, and I would really
want to hear the presentation.
Want to hear her.
Very well.
I know you're anxious to.
No, just matter, asking. Very well.
I would love to hear the presentation before we quiz the presenter. Yes.
Agreed. All right.
Yes, and the chairman seems to be breaking her own rule.
Let us hear the presentation. Let us hear the presentation. Very well. Please proceed.
Thank you.
Let's go.
Thank you, Madam Chair. So we're saying that the fact that the Charter does not protect the pre-charge defendant supports an argument that there's no power to create him as he has been created, especially bearing in mind that this post-charter legislation, as the bill is, which has created this pre-charge defendant, simultaneously strips him of many of the constitutional rights that become engaged because of how he has been created, and that the post-charge defendant has. Yes? So we're moving on now to look at the argument of the absence of the entitlement. Now, when we look at the Constitution as well as the Bail Act of 2000, our present act, they both provide for an entitlement to bail for the accused, charged with an offense. And this entitlement covers all persons in relation to bail. The proposed bill removes this general entitlement under the present act. And actually, the word entitlement is only mentioned once, and that is at 61A, which is in relation to persons who have committed an offense punishable with imprisonment. And then, so we look at then at a hierarchy of the defendants that under the bill that would come before the court. Yes, so the first one would be persons charged with an offense punishable with imprisonment. They have entitlement to their name. We get to B, there's no express use of the word entitled, but there is use of the mandatory language shall be granted bail for persons charged with offenses not punishable with imprisonment. But when we get to the pre-charge defendant, there is no entitlement, nor is there any use of the terms or the phraseology shall be granted bail. And so our argument is that this person, birthed by this legislation, is the least culpable in law and arguably the most vulnerable under the bill, yes? And yet it is he who has been placed in the greatest peril by the bill as it is. And so we are submitting that, it's our humble submission on the point that the section really from the act should be retained and be widened. Of course, we are not here to say how, but as you can see what we have written here, it would incorporate this defendant who has been created. Yes? And so moving on to 4.1, we're saying here that the absence of an entitlement, when you couple it with a comparative analysis between the pre-charge defendant and the post-charge defendant under the bill, as well as the post-charge defendant in nation that the court struck down, that was created by the amendment that the court struck down as being unconstitutional, we're saying that the pre-charge defendant under this bill is in the worst predicament of the three. And so to make that point a little clearer, we have created here pretty much a story of this person. And I think it speaks for itself. And so I'll just look at it quickly. So I'm at 4.2, Chair. Pre-charge defendant on bail or remanded in custody, because that's another thing. We talk about pre-charge bail, but the truth is at the same time we created pre-charge bail, we also created pre-charge custody. And so more is spoken of this pre-charge bail while ignoring to some extent that there is pre-charge custody, and there's also pre-charge custody without a roof on it, without a ceiling on the time that such a person could spend in custody. All right, so going back to 4.2, the pre-charge defendant, as birthed by the bill, is arguably a most unfortunate person. His woes range from an insufficiency of evidence, which nonetheless leads to his arrest, the inevitability that he will spend some time in custody without the opportunity of bringing a habeas corpus application, to the absence of a right to fulsome disclosure and no access to legal aid, as well as no legislated voice in the consideration of whether bail is to be offered to him. If remanded in custody, he cannot insist that he be offered bail because he has no entitlement to this right. Furthermore, the same police force, which wishes to eventually charge him, can also make the decision to deny him bail. And if he's denied bail, there is no fresh rehearing of his matter. Neither can he ask the court for a rehearing because of the passing of time. He must wait in custody until the judge exercises discretion to bring him back. Any application he makes must satisfy stringent conditions before he even has audience in the court. Instead, he must engage in a potentially expensive appeal to have any real hope of being offered some liberty. And even if he's offered bail, his liberty is likely to be restricted by onerous conditions, which if he breaches any of them, he, and likely his surety, may be subject to arrest, detention, further imprisonment, and even loss of property. Furthermore, the police can ask for repeated extensions of his bail, even after he has spent half of a year just waiting for closure. He's promised no complete picture of the allegations against him, nor is he told when his life will return to normalcy. He's unable to anticipate or plan for the unconditional release he may eventually be given. If he's not offered bail or he's not able to take up the bail, he remains in custody, plagued with the same uncertainties as a pre-charged defendant on bail. It is clear to him, whether he is on bail or not, that his fortunes would have been better if he were charged. And so a pre-charged defendant who has been refused bail by the justice of the peace or of the police has less than the defendant in nation. Why? When we go back to the words of the president of the Court of Appeal, as he now is, but then was Justice Brooks, in looking at nation, he said, instead of a right to bail, the person held only has a right to be brought before the court. It is then for the court to decide whether he should or should not be granted bail. That person would have the opportunity to show why bail should be granted. The above is the court's explanation of the invidious position that a post-charge defendant who under the earlier amendment to the Bail Act lost his entitlement and who had the burden to show why he should be granted bail, and the court struck that down as being unconstitutional. However, when you compare him to the present pre-charge defendant, he certainly has more. It goes on to say the defendant in nation at least had the opportunity, in the absence of an entitlement, to show why bail should be granted. However, upon our understanding of the bill as it reads, the pre-charge custody defendant under the bill has neither the entitlement nor the opportunity unless he appeals. And a helpful picture can further be gained from comparing the post-charge defendant here at Nation with the pre-charge defendant. And you notice that table is created for ease of reference. So what is the objective of what was the objective of the legislation in Nation? It was to fight serious crime, etc. What is the objective here? Also to fight serious crime. In Nation, there was no entitlement to bail. The pre-charge defendant here has no entitlement to bail. In Nation, he had a presumption of innocence. Here, the defendant has no presumption of innocence because it's only offered to somebody who is charged, no? Opportunity in Nation, there was the opportunity to show why bail should be granted. In the bill, there's no opportunity to show why bail should be granted. In Nation, there's a sufficiency of evidence that led to the charge. In the bill, there's an insufficiency of evidence, and he may never be charged. In Nation, there's a right to disclose everything the Crown has against him. In the bill, there's no right to disclosure of anything the police has against him. In Nation, he has been charged with an offense. In the bill, he has not been and may never be charged. And in Nation, he has due process. The argument here is that in the bill, he does not have due process in the way that the law intends it. And in Nation, if retained in custody, he has a right to trial within a reasonable time, and it should say and he must be released on bail. Whereas under the bill, if retained in custody, he has no right to bail, and he has no idea if he will ever face trial. And of course, as we've said in Nation, it was found to be unconstitutional. Here, the question is being asked. So where the pre-charge custody defendant is not granted bail and is brought before the court under Section 5.2, the submission is that the legislation should ascribe him a right to be heard, and it should further impose a duty on the court to consider the submissions in the decision-making process. And of course, we go further to ask if perhaps release under investigation, as practiced in some other territories, that would fit our constitution, would be a better schema crafted as opposed to the creating of the pre-charge defendant in the way we presently have him. Or in the alternative, it is also submitted that an entitlement to bail for the pre-charge defendant is necessary. And of course, that even when there is none in the Constitution and there is none in the present act because it did not see him in this light, that it does not preclude the proposed act from conferring such entitlement on him. So, Chair, I'm now at number 4, the provisions in relation to pre-charge bail. And as we said, it should be noted that the bill doesn't make any allowance for or contemplate an application or submissions being made by the pre-trial defendant the first time a decision is taken for bail touching and concerning him. What 51A and 52 as per 51B does is set a set of factors that the deciding official should rely on. But it does not oblige them on its reading to hear from the pre-trial defendant, or even if he does say something, or allow him to participate in the proceedings. And further, that even if he makes submissions, that those submissions must be relied upon. And sections 9 and 11 permit a deciding official to review the bail decision, but it is done in a restricted way, either by a review or a rehearing, and both of them have condition precedent. And what these conditions precedent do is shrink the number of persons who can therefore make this application. And we are saying that by doing that, firstly by using the process as stated here, the review, it's that it's unfair, as the defendant was not given a standing in the earlier considerations, and yet at this stage, his ability to make the application, so to speak, is restricted by conditions that he would have to fulfill to have audience. Yes? 5.3. Now, let us look at the provision at Section 22 of the present Bail Act. It says that where a person who is arrested or detained is not charged within 24 hours after such arrest or detention, he shall be brought forthwith before our present parish court judge or justice of the peace, who shall order that the person be released or make such other order as the judge or the parish or the justice of the peace think fit, having regard to the circumstances. And we agree that there is this order here, but this order is our submission, does not contemplate the trajectory that a pre-charge defendant can face, yes, while he retains that status. And it's true that 5.4 then goes on to say in comparison, but that's not a fair analogy. It's because that section was left out. What happened then is that any inconsistency in the application will likely violate the principle of legal certainty and deny those affected their right to equal treatment under the law because of the unequal application. And we just want to say that this is against the background that this subject is already being deprived of his fundamental right to liberty. And this is where there's an insufficiency of evidence to charge him. And we say here that he has his constitutional presumption of innocence. Of course, he doesn't, because it says person charged. But since he's being treated as a regular defendant, in this context, we're applying it to him. But even more importantly, again, this is against the background that the state, under the present charter, has responsibility to promote the universal respect for, as well as the observance of his rights. And this is why, going back to 14.1, it is so important that there is a law created that is reasonable and that it is fair to him, as set out. And as we've said here, I think I mentioned this part already, so I don't need to address it again. All right, let's look at number 5 now, the grounds on which to deny pre-charge bail. And those are the facts. They're listed at section, let me see, an examination of the factors at section 5.6AE begs the question, how, by virtue of the provisions stated, will the defendant's remand in custody enhance, expedite, make possible the constable's investigation? And so we're asking really, how is the aim of the investigation rationally connected to the restriction? Well, not the restriction really, the deprivation of his freedom if he's in custody, and the restriction of his freedom if he's offered bail. The factors listed, and note also, this is against the background, that those factors listed are discrete, they're not cumulative. One single factor under section 5.6A to E is a sufficient ground on which the court could actually deny the or any of the deciding officials, because it's not just the court, any deciding official could actually not grant him bail. When we look at other territories, the very few which resort to this sort of thing, it is clear that the investigative purpose of securing evidence, or preserving evidence, or obtaining evidence is put at the forefront, and not in the loose way that it is, well, I'm not even sure if it is really incorporated sufficiently at 5.6, which is why we are begging the question, although we believe that that is the intention. And so we say at 6.1.1 that the provisions can be summed up in the following words. Because I, as the officer, need to do these things, you need to be in custody. And really what it should read as is that they should demonstrate rather that in order to be able to do these things, you need to be in custody. Or carrying the argument further, you need to be brought in and then be placed on bail. And so the argument is that it is submitted that the factors listed, except for his conduct, are more reasons why he cannot in law be charged. Yes, it really evidences, or they evidence an insufficiency of evidence and are not really rational bases on which it is to deny him his right to liberty. I could understand if they were only being used for the extension, because they are the same factors now that are used for an extension of the bail of a pre-charge defendant, and they fit more comfortably in this context, that the officer needs more time. He wonders if he gets more time, he will be able to charge him, and that sort of thing, but not for the initial purpose of denying him bail. And so we say that at 6.1.3 that besides these investigative aims of evidence gathering as individual bases for keeping an innocent person in custody are difficult to reconcile with the language of the court that makes it clear that the liberty of the subject is a normative position. And we look at Philip Stevens and we look at Gowdy from our jurisdiction. Furthermore, it should be noted that the factors contained within Section 5.8, which are used to determine if conditions should be attached to the pre-charge grant of bail under Section 5, are instead risks under Section 6 on which he should be denied bail, and whose non-existence or whose existence can be controlled by conditions. They ensure that a post-charge defendant should be granted bail. And of course, another critique is that the language there is somewhat, in a sense, vague. For example, when we speak of his conduct there, as you can see, the paper is asking, is it conduct in relation to the offense for which he's arrested? Is it his conduct in general? Do we mean his antecedents if he has a criminal record? Or is it that all of them are being borne in mind? And I stand corrected, but if I understand even the UK provision, it would appear that the longest he could possibly stay in custody without being offered bail is 96 hours. As I say, I could be wrong. But he's required to come within the 24, and then there's a 36 window, and then there's a reconsideration. I suppose the point I will say, without committing myself to time windows, is that the time windows are shorter and that there are ceilings given. And the objective, one can see a very clear tie between the objective of making him into a pre-charge defendant, whether in custody or on bail, are clearly tied to the objectives of what the officer wants to accomplish, and that it needs him to have that status for that to be done. Argument here is that it is not so clear on the bill as contemplated. Then we look now at attaching conditions to pre-charge bail, and the relationship between the factors at the bail consideration stage and the factors at the condition stage, it is submitted are difficult to appreciate. Yes. So, as per Section 8. A deciding official who grants bail under this section may require the defendant to comply with one or more conditions as listed under Section 9, if in his discretion the condition is necessary to control 4 listed risks, which are as follows: surrender to custody, not commit an offense while on bail, do not interfere with witnesses, or does not obstruct the course of justice. So when these are the bases on which the conditions are going to be attached, then what is the relationship between the Section 5.6, those are the grounds to deny bail, and Section 5.8, conditions of bail? Because it would seem that the conditions attached to the grant of bail have no connection to the reasons for denying him bail. And it is perhaps because I'm coming from the formula that we use presently under the Bail Act, yes, in relation to a post-charge defendant, that one clearly sees what are the bases for denying him bail, hence going on to look then at what if conditions can manage those risks that it would pose, or that would be posed if he were to be offered bail. And so it is submitted that the argument that the pre-trial defendant is likely to interfere with the potential witness or obstruct the course of justice by inter alia, destroying evidence, are stronger arguments than the bases that are presently listed in the legislation for denying him bail. And furthermore, by virtue of Section 5.9, the conditions to be attached to his bail are, well, not all of them, I suppose. They're in the same way as the ones, or very similar to ones that presently exist. But for someone of his status who is not charged, then they are onerous. And in particular, there's a Section 5.9b that even requires him to report to the nearest police station before he travels outside of his community, which clearly would be extremely onerous on him, considering how small his community may be and the need to travel at different stages in relation to his daily life. Yes. Now, having looked at the grounds for denying him bail, having looked at if he's granted bail, the conditions that can be attached, we're looking now at what happens if he wants to vary the conditions of pre-charge bail. It would appear that the first time he comes before the court, well, let me not even go there. Let me stick with what we have here. So Section 510 makes provision for a pre-charge defendant to appeal if he wishes to have any condition varied. Yes, and this means that the defendant is appealing the earlier decision of a constable, a JP, or a parish court judge. And we note that, of course, that he would be appealing from one conditions of bail. And the bill as drafted actually contemplates that a person on pre-charge bail being in breach of the conditions that have been placed on him. The consequences, of course, are that he may be taken into custody, the bail may be revoked, and if he has absconded, he may be subject to imprisonment to a maximum sentence of 7 years. 7 years before the circuit, 5 before the lower court. And then, if a sentence is imposed, the sentence that is imposed on him, if it is imposed, the legislation actually says that it is to be served consecutively to the offense for which he was granted bail. Yes? Assuming, of course, that he goes on to be charged and is convicted. Bearing that in mind, nonetheless, the first observation is that it is unusual to see Parliament legislating that a sentence shall be served consecutively, and especially consecutively in this context. And this is usually, the question of it being consecutive is usually left to the discretion of the court, and even then, my experience is that it is infrequently exercised. In this case now, the court is not being given an option to make that determination. The main concern, however, is that the legislation makes a criminal out of a man who has not been charged with a primary offense, nor has he had his innocence tested in relation to the said offense. And so we're saying really then that the treatment of the pre-trial defendant does not accord with his status under the Constitution. Then we look now at the extension of pre-charge bail. And I must say, Chair, there are some provisions that are not clear, and it could be that, therefore, the interpretation of them is incorrect. And so I look forward to be informed as to what that position is. So let us look here now at Section 5. This is not one of them, mind you. I think this one at most would have to at least be ambiguous, yes, because it's definitely not clear. Section 5, subsection 457, governs the extension of the bail of a pre-charge defendant and the power of the court to grant extension of that bail. But subsection 5.4 allows for repeated extensions for a further period of 6 months. And that's another thing. The fact that even his status could be for 6 months is in itself arguable, because that is a long window. But be that as it may, legally, therefore, a person could spend years on pre-charge custody. Why? Because the fact that in its first iteration, a pre-charge defendant can spend up to 6 months on pre-charge bail is already onerous. And it can be argued that this length of time, regardless of the type of case, is unreasonable. What is not in doubt, however, is that the proportionality of pre-charge bail as a legislative tool to control crime and its negative effects would change drastically as the length of time the pre-charge defendant remains on bail increases. So the argument here rather is because Section 5.4 refers to Section 5.5 and Section 5.5 refers back to Section 4.4. So it would appear that the police can simply go back and ask for an extension of the pre-charge bail before the further period of extension. There's one view that it may be for just a year, that there's a ceiling for a year. But the better view it is submitted is that when it is read, it actually creates a circle, one provision moving to the next, and therefore there is no limitation. There's another point too, when you look at 5.4, that it is not clear. We have 3 periods under consideration, and we're not sure when it is that the 6 months, the first initial period of 6 months, when is it would actually begin to run. Yes? So it could be that, is it starting to run from the time he was arrested? Is it starting to run from the time he was offered bail? Or is it going to run from the time he takes up the offer of bail? No, clearly the best position for him would be from the time that he has been arrested. But because that is not made clear on the face of the provision, submission that it is open to multiple interpretation and at the peril of the pre-charge defendant, as is referred to here. And so it is submitted that either there should be no extension of pre-charge bail, or in the alternative, the legislation should only contemplate one extension. And this extension should only be contemplated in exceptional cases, because not all cases are equal, not all cases require the same level of investigation, and therefore the time required to carry that out. And it certainly should be for a period that is significantly less than the 6 months, if the legislation remains with that window that he would have already spent in the initial window. Then we look at the unconditional release from pre-charge bail. And I think the arguments there are, I don't need to go into them because of the limitation on time, but I do recommend them because of the point we're making there. And then to get instead to 7.6, pre-charge bail and looking at a voluntary option of surrender. What we're saying here is that even if the legislation were to retain the pre-charge defendant, that bearing in mind that upon arrest, the police can use force to execute the arrest. And must use some level of force, no? But force to the extent that it is more than just. And this is against the background that the power of arrest in law is really only to be exercised in those circumstances where it is necessary to do so. Meaning, when the law as it presently is, an officer should resort to an arrest of a suspect only when that is the best option under the circumstances, meaning he would have stopped and thought about, is this a suitable instance for which I need to arrest this person? What are my other options? Do I really need to do that? And so it's against that background now that, bearing in mind the peculiar status of a pre-charge defendant, a voluntary option of surrendering at a police station could be utilized where suitable, instead of an arrest and the usual ignominy that accompanies. And that the voluntary option could also prevent circumstances where allegations could be made that the police have acted arbitrarily and high-handed. And this option would put the state in a good position, because it would show a positive, it is a positive demonstration of the state, not only acknowledging the existence of the subject's right, but also enforcing them as is constitutionally required. Now, there are 2 other points. Madam Chair?
Yes, yes, Ms. Colo. I'm listening attentively.
I have no doubt about that, Madam Chair. What I wanted to ask. Okay, very well. That means
but I'm going to ask you to wrap briefly. The matters you have raised, because we would like to have some interaction with you, but I'm doing my best not to interrupt you at all.
It is appreciated, Madam Chair. Then what I will do then is just look at the 2 other points in relation to the pre-charge defendant, because I don't think I will be able to get on to anything else if you're waiting on me to wrap up. I'm sorry. As you would know, at the law school, we get at least an hour to teach. And so it is a hazard of the profession. So I will just instead... So
is this the only area where you have focused on the constitutionality question?
No,
because your presentation speaks to this scheme, the general, going through identifying issues with the provisions and the constitutional soundness.
No, Madam Chair. And the reason for that is that the schemata itself the different schemata created in relation to the post-charge and pre-charge have implications for throughout the trajectory of the criminal matter. And so you find that there are different points that are raised constitutionally. And as I said, in relation to the post-charge defendant, when you look at the newly created Section 7.2 and the two bases, well, the three bases, I think, that are created under there on which are now creating independent grounds on which an accused person, post-charge accused person, can be denied bail. We submit that there are also constitutional issues with that. It is just that in relation to the pre-charge defendant, there's also the issue of disclosure to him in terms of equality of arms and, of course, legal aid in relation to his right to attorney to right to be represented at this stage based on the predicament, so to speak, that he has been placed in under the act, especially if he's the bill, especially if he's impecunious or / ignorant, I suppose, is for want of a better word. But I'm quite, as I've said, Madam Chair.
May I ask if you could, in the interest of time, then just summarize the points? We do have the paper, and we will go through, but if you could summarize the main points in respect of the other areas.
I will try, Madam Chair. But feel free to stop me whenever you are ready.
We will have to provide an opportunity for members to ask any question or seek any clarification. And I myself have a little bit of exchange.
Very well, Madam Chair. So in relation to, I've gone on to the back of the paper at number 14 at 15.1 to the availability of legal aid and the requirement for that under the Constitution where equality of arms is concerned, that the pre-charge defendant, based on what he's being visited with under the bill, that especially where he needs their inter partes hearing and he needs to serve notice or he needs to appeal his the fact that bail was not granted to him, or appeal the variation of his condition of conditions attached to his bail, that those will rarely require, in many instances of persons who will fall in this category, that legal aid is offered to them. And in terms of disclosure, there does not appear on the bill that there's an obligation to disclose all the relevant information on which the police are relying. Yes, there is truth that at the stage of an extension for an application for the an extension of bail for the pre-charge defendant, that an affidavit is to be filed, but that is all that is stated there. Yes, so and we don't even know if he will be ambushed by the service. And we say that just to say that when the legislation doesn't clearly set laws in place that makes it fair to him, that cannot be excluded as a probability in the way that the law functions. And again, I compare this to the provision in the UK. Mind you, I was using the Blackstone 2022, and I think they had a later update this November. So I'm not sure that part would be in it. But the point is, though, that there's fulsome disclosure provided for at all stages that he's while he's on pre-charge, well, both bail and in custody. And it goes beyond just a providing of the reasons that the deciding official has decided not to grant him bail. In our view, that is extremely limited and would not meet the law or the spirit of disclosure as is provided either to the post-charge defendant or as the law itself, the common law, understands disclosure. And it is practiced in this jurisdiction. Going now, you've seen the point that we've taken in relation to sureties, that placing sureties, someone who offers himself as a surety here under the present provision. And it would seem whether it is for the pre-charge or the post-charge, that what has happened to him is that he's put himself almost at the same peril as the person he's being a surety for. And when we compare it to the present provision that we have, that limitation is just solely to him ensuring that the accused surrenders to custody, or the defendant then surrenders to custody. It is not so wide here as for him to ensure that every single condition is not breached, or that he must then suffer the consequences of same. Even where the law, the present act, extended that to parents. There were parents of minors, and the parents would have had to agree that they were accepting such a limitation on themselves. And then the court, when the legislation went further and said, all right, when that is the case, the most that you can lose is $50,000. So they even saw a necessity to put a ceiling. Here, there is no ceiling. And as I've said, in many respects, in terms of the likely consequences, one is hard to differentiate the surety from the man who he's standing as surety for. Another short point is in relation to the meaning of defendant. We submit, Madam Chair, that the difficulty that's beginning in the act in the bill is really flows from calling this man a defendant in the first place. I know that is the legislation that has created him, but one still has to question the fairness of attributing to him a terminology that has always had a particular meaning. And, you know, under the present act in section 2, it says a person charged with or convicted of an offense. Yes. And the argument we make, we're at 13.3, is that this equalizing or equating of him is a better word, with the equating the post-charge defendant with the pre-charge defendant by the use of the term defendant to refer to both allows inter alia for two different persons with two different sets of rights and two different statuses under the law to be seen as and treated as the same. And the argument we then make is because when clothed with the same cloth, the term makes the similar treatment more palatable. And it is our submission that the word should be limited to the true meaning that it has, really, and that we should find another term that equals the status of this man for whom there is no sufficient evidence to charge him and who may never be charged and who does not have the sort of rights or protection that is offered to, I won't say his post-charge brother, because he's not really in law, to the post-charge defendant, that we make this distinction clear and the treatment that flows from this distinction equally clear. One other point I will make before closing, Madam Chair. Section 1A reads, where the deciding official is satisfied that there are grounds for believing that the defendant. Now let us contrast that to the provision under the present act. It actually says the court or justice of peace, police officer is satisfied that there are substantial grounds. Now what the present bill has done is intentionally remove substantial from the equation. And it has value that they have removed it, meaning when we go back to look at Philip Stevens, which was one of the first interpretation of our present bail act by Lord Sykes, as he then was, he gave the particular meaning to that word. He said substantial means solid. It means weighty. It means of real significance. It means rational. And so the submission is that removing it is an apparent weakening of this test to allow for bail to be denied, and that it is therefore untenable under the provisions of the Charter. Section 7.2, the argument that we're making that it appears to be in violation of the defendant's constitutional right to presumption of innocence and due process by asking the judge at that stage of bail to make a preliminary determination as to his guilt and aimed at denying him his entitlement under the Constitution. His geographical location, which is a direct discrimination against him in the absence of any of the risks commonly associated with the consideration of bail. Because if we remember, Section 7.1 that states the risk is independent of Section 7.2, and then the law states that the conditions that are mentioned are only controlling 7.1. So what 7.2 does is give these independent grounds, which the law no longer wants to know if any condition can control them. The law is just simply saying, look, did he commit murder? And well, the allegation that he commits murder. Is it that on the Crown's case, there is no self-defense? Is he from is he from a Zozo area? And the different factors that are listed here on 22, it says to the court, on this basis alone, when you look where he's from, plus when you look at the evidence, these are bases on which to deny him bail. Presently, those bases are more factors that the court would have to look at to see if a risk any of the main risks are made out. That is that he will abscond, he will interfere with witnesses, he's likely to obstruct the course of justice. And then the judge, after doing that, would still have to go and look and say, in spite of these risks existing, yes, can they be controlled by conditions? And so we've taken him out of this formula that the court uses to protect the rights of the post-charge accused, who clearly has his presumption of innocence, and I've left him, I've pushed him over somewhere else in a place that makes him way more vulnerable. And we're saying that this push is likely to be found to be in violation of his rights under the Constitution. And I believe, Madam Chair, in trying to end as quickly as possible.
Just another minute to go to wrap. Please.
I will stop, Madam Chair.
All right.
I will stop.
Thank you so much for the presentation. I invite members to now interact with you. I see Member Paulwell hand.
Well, first of all, Chairman, I have to commend the law school, and in particular Ms. Kohler, for the presentation. You know, I was just listening and thought to myself that our law school perhaps doesn't participate enough in these kinds of deliberations, especially when you hear the level of scholarship that we are witnessing this afternoon. And I will start by entreating you, Ms. Kohler, to see if we could get on all bills that come before Parliament a law school position. I think it will help the process, and we all, lawyers and non-lawyers in this House, will benefit tremendously.
I don't know that we have the time to do this, and I must confess, as I've said, there are errors in here because of the very little time I had to make these arguments, but I accept those flaws as mine.
Yes. All right, so you have left me quite provoked, because I can now understand why in our courts the judges would always, in the defense of the position you have stated, the liberty of the subject is a normative position, why this issue of pre-charge situation, as would obtain in, for example, a state of emergency, why there would be a difficulty in any regulations being done to satisfy what you perceive as the constitutional requirements. I am wondering, and I agree with you based on your submission, that we will have constitutional issues with these provisions relating to pre-charge bail and the whole definition of a defendant who is not charged but yet defined in this way. Are there any circumstances that you believe, because I'm understanding you to be saying that these provisions would be frowned upon by a court and that they could very well be deemed to be unconstitutional? And we certainly don't want to go that route in passing laws here that will be struck down. I'm wondering if there can be some consideration for some of the peculiarities that exist in Jamaica today, because I agree with you that we ought to see as absolutely inviolable the liberty of the subject. But we do have situations where, and I do refer to some of my own people, fellow Jamaicans, who operate in certain vicious ways as terrorists, and whether or not there could be some category. You've spoken about serious crimes, but can we separate serious crimes, and murders and those things are serious crimes, but what about acts of terrorism that could see an entire community being terrorized by people who wantonly kill and destroy, and whether in that type of scenario there could be definitions that could be proffered that could satisfy the courts now that acknowledge, well, we have to concede based on our new Charter of Rights and their interpretation, do give very liberal interpretation. And in that scenario, whether you believe that a pre-charge arrangement in a bail act could ever see the light of day in terms of approval by the courts?
Well, that's a heavy question, and it would have to be subject to further research. But tentatively, from my standpoint, I would say yes. There is a possibility to legislate for someone. I won't call him a pre-charge defendant. I don't even know if there needs to be a pre-charge situation. But certainly, I believe that there is a possibility to legislate something that is constitutionally correct and that at the same time meet the objectives of the legislators in our crime-fighting task, so to speak. It is possible. Our argument is just that at this look at, this is a draft bill, no? This is the draft, and our arguments are also in draft. But we do believe that, indeed, with enough time, with the correct starting points, in terms of how the bill is legislated, that can be achieved.
But perhaps, Madam Chair, we could impose a little bit more on the law school to assist us in providing us with those words that you think could enable us to have this scheme in place without the violation of our Constitution, as some further work that you can do to assist.
Thank you for your input, Member Paulwell. Any question from other members? Are you seeing any hand raised online? No question?
Madam Chair, perhaps I could just invite Ms. Kohler to consider whether or not a detention order not described wherein a police can actually take you in and after 72 hours, then that detention order is further extended by a police officer, a senior police officer, and perhaps to take it, depending on the level of investigation which is being carried out, take it up to, say, 30 days, and at the end of 30 days, whether or not that the court would then have an opportunity and whether or not such a scheme being introduced would then violate the provisions of the Constitution.
Well, as any lawyer would tell you, when you introduce terms and we have to check each term and then we have to see the term itself, then the relationship between the terms. So all of that would be difficult. But if I hear you correctly, having the police being the one to take him in and then the police being the one to, not in a short window of time, but such a long window to make the decision that he should be remanded in custody for up to 30 days, I believe there's already case law that shows that is unacceptable. And the bill recognizes that. This is why after they have him in the police's custody, they have him in the police custody for no longer than 96 hours, which really matches the case studies we've seen so far. And this is why he's then passed over to the court. But even when he's passed over to the court, the submission is that doesn't make it not a breach of his right under the Constitution. So, as I've said, we understand the issues that we're addressing, but the submission is that detention, anything that goes against the liberty of the subject and is not properly grounded in law, is not fair, does not allow him opportunities to test it in the way that he should, and goes over a certain time, is going to have constitutional implications.
You're making it almost sound like your right to liberty is an absolute one.
It is not. It is not. I spent many years as a prosecutor counsel.
At what point do we say then the state has the right to restrain that liberty? For what period?
There are already bases laid down in law. I'm sure Madam Chair has already mentioned them, that, when you go to the Constitution and you look at Section 14, there's a whole long list of bases, including separate provisions for even emergency situations. But remember, we have to look at the status of the person. It's one thing when someone is charged with an offense. Yes, there's another thing when he's not charged, and we're not even sure that he ever will be charged. You see, we have to be very careful. How far is he away then from the citizen who is not arrested under those circumstances? How far is he away? And so if we give in too quickly, or create laws that encroach on these rights so readily, then the flip side of that is that we're going to have a situation where the encroachment is going to continue to erode and until get to the citizen who you consider perhaps should never have been charged, perhaps should never have these difficulties. So it is not that we shouldn't create something and we should not respond to the problems that we have as a nation and that are particular to our people. But it's just that those responses have to be constitutionally sound. And it is left up to the court to make this decision. No? These are just our submissions.
Chair, whilst I appreciate my friend's argument, I'd just like us to get to this point where we perhaps adopt an approach which is I see in other jurisdictions, where the state may want to consider for such persons, if they are indeed affected by an act of the state may want to compensate them, and I'm not saying that we can afford that, and so we have to be more careful, because I know in the UK what they do, if you've been charged and you're discharged, you're set free at the end of a trial, you're compensated, the legal fees and so on are refunded. That's another question. So if you're detained, if you're taken in, if you're suspected of committing an offense, and there's enough evidence, because I can't see a situation where the police take you in, detain you, because there's a suspicion or some level of evidence that you have committed an offense. They detain you for 72, 96 hours. That is not a situation what the Constitution would contemplate as being necessary in a free and democratic society to protect the very. I'll have to flesh it out a little more, but I somehow think that will have to be borne in mind, because if we were to allow an absolute right, privilege to exist, then we would be reneging on what our obligation is, that is to protect the larger group must protect the smaller.
Thank you. All right, just before, I think Member Bunting has his hand up, but just Member Paulwell stated that we ought to see as absolutely inviolable the liberty of the subject. And in response to Member Campbell's comments, Ms. Kohler, you agreed that the liberty right is not absolutely guaranteed. Did I hear correctly?
I'm sure you're as well aware of that as I am.
Right. So on the one hand, we have one member asking us to view it as absolutely inviolable, and another in respect of the comment. I
took that in context, because I took it that when he says absolutely inviolable, he meant in relation to how the submissions have been slanted, and not that he was trying to say that such a right cannot be.
Would you say that the provision at Section 14.1 Section 14.1 of the Constitution provides an answer as to whether the right to liberty is how it is guaranteed? Would you say that it expressly provides that it is not an absolutely guaranteed right? Would you agree that's a proper reading of the provision?
I accept that there's perhaps only one right, the right to a fair trial, that is completely inviolable. And even then the court then makes a determination of what exactly then is fair. No? Almost every other right allows for some encroachment. The right to liberty is no different.
All right, we'll come back to that. So we can agree that the right to liberty, as important as it is and as normative as the courts have indicated it should be viewed, is not absolutely guaranteed under the Constitution of Jamaica as set out at Section 14.1. Member Bunting, you have your hand up.
Yes, thank you, Madam Chairman. Where I am, my signal is very weak, so that's why I don't turn on my camera, because the video uses up bandwidth. But I just want to say I very much enjoyed the presentation from the Norman Manley Law School. And a small question, with reference to the term pre-charge defendant being prejudicial or potentially prejudicial, couldn't we just use the word detainee? That's a simple question.
Yes, it can be used. Is it a better substitute when compared to pre-charge defendant? Arguably, yes. But it doesn't mean that that's the best one. And of course, I'm sure Madam Chair perhaps will think of others. But we did suggest one or two in the paper itself, but we are not saying those have to be the way. We just think the equating is an issue.
Individual presumed innocence?
But I don't believe that his innocence is actually questioned at this stage, him not having faced that charge. It doesn't even apply to him at this stage. I should look what we used. Now that you've mentioned it, Member Bunting, let me see just very quickly what are the
while you're looking it up. The three stages for which the grant of bail is provided for, at each stage, pre-charge, that individual would really be a suspect, and in the criminal law, that is how the person is regarded. When charged formally, the person is an accused, and after conviction, the person is a convict. So those are standard terms in criminal law parlance for the three stages. It's the suspect, it's the accused, and the convict. But you have recommendations in the international law arena which suggests that the use of the term defendant may be more palatable. But we will look at that when we are responding to the suggestion you have made.
Very well, Madam Chair.
But before someone who is reasonably suspected of having committed an offense is charged, that person is regarded as a suspect. And that is the term that is used in our jurisdiction to the suspect. And then you have the accused who is formally charged. And if you are convicted, you are regarded as a convict. Member Williams, you have your hand up.
Could I just say, Madam Chair, the ones we have here at page 25 of the presentation, we mentioned as suggestions, and these are again just suggestions, a person without charge, so it would be PWC, or as you've said, with relation to the suspect, a person suspected of committing an offense, a PSCO, or some other similar description. So person without charge or a person suspected of committing an offense are the two that we, at short notice, came up with.
What page are you directing me to on your submission?
Page 25 of 29, Madam Chair. It's actually in the footnote, so perhaps that's why you didn't see it. It's at footnote 38. Yes.
I see. I note that having raised the constitutional issues at page 8, your submission for consideration for the committee is threefold really. First, you're submitting that instead of the creation of a pre-charge defendant, an option such as release under investigation, the RUI, could be considered. And secondly, in the alternative, your submission is that an entitlement to bail for the pre-charge defendant is necessary. The absence of an entitlement for this newly created defendant under the Constitution does not preclude the proposed act bestowing an entitlement on him. We know these are the submissions that you're asking the committee to consider at the end of the issues you have raised.
No, there are a number of submissions we've made.
Right, just in respect of this.
In relation to this here,
yes, right. And
as I said, the truth is the submissions run throughout, but as you have identified, those are submissions that are in the
and at another, on page 13, your submission is that there should be no extension of pre-charge bail, or in the alternative, the legislation should only contemplate one extension in exceptional cases for a period significantly less than 6 months already spent.
Yes, Madam Chair.
You have a recommendation in respect of terminology. Is there any other question? Any other hand raised? Member Williams? Yes.
Yes. Might I say, Madam Chair, let me join my colleague, Member Paulwell and Member Bunting, and the others who have commended the presentation from the Norman Mandela Law School through Mrs. Kohler?
Miss Kohler.
Miss Meridian Kohler.
Miss Meridian Kohler. I too find it quite interesting. On the issue of Section 14 of the Charter and the question of whether, rights are absolute. My understanding from my brief perusal of the presentation is that I don't get the impression that the law school is positing that rights are absolute under the Constitution, because, of course, Section 14.1 speaks to except on reasonable grounds, and I'm referring to the Charter, on reasonable grounds and in accordance with fair procedures established by law. Now, I wanted to ask Ms. Kohler a question. And this is general. I'm going to be specific in a short while, but generally speaking, is the law school opposed to the philosophy of pre-charge bail? Generally.
I don't know, to be quite honest. The submissions are from the law school, but I would still hesitate, because I was given the lion's share of preparing them, of making a comment as to the general philosophy of the law school. And even then, we then have to contextualize. What do we mean? Pre-charge bail, as it is here in the bail, in the proposed act, or pre-charge bail?
As proposed. Yes, and fair enough. As proposed in this act in particular, is the law school's position specific to achieving fairness in terms of the provisions and the reasonableness of the pre-charge bail, this introduction into our law? I know you're presenting individually on behalf of the law school, but I see you as the voice of the law school now in terms of your presentation, because obviously you are representing the voice of that
is a fair comment, member. And that's why I've said to contextualize it in all fairness to you. Because you're right, I am here in that capacity.
Yes.
But you know how it is when work is given out and how much it is that has to be done. Yeah. So, yes. So I would hesitate to speak to the law school having a position in general.
I want to move from the general.
I would say that yes. On this bill, the pre-charge defendant as created on this bill is what we find objectionable. And not necessarily that there can be no pre-charge defendant at all.
Or
yes, we are willing to. There is a view, because we did make the argument on two different in the alternate, whether or not the charter, the newly constituted charter, really did contemplate this sort of pre-trial defendant at all in its provisions, and that if it did, then certainly the schemata that surround him make it likely to be unconstitutional. But we're not saying, and certainly not at this point, without further research, without further information, and myself dedicated to the topic, say that it is not possible at all to create one.
And that is what I was trying to get at before I move to the specific provisions that you have so lucidly and clearly, delineated in your presentations on the respective provisions. But I wanted to before I get to that, just to clarify whether as you have just said, whether constitutionally, generally from a constitutional point of view, the body which you represent is opposed in principle to this pre-charge defendant or pre-charge bail philosophy that we are now embarking on. Because if it is from the beginning, your position is that it is not accommodated at all in our Charter of Fundamental Rights and Freedoms, then irrespective of how we dress it up in terms of the legislation, you might have a problem. And I just wanted to be clear on that before I get to the specifics.
That's a fair point, but I think I should perhaps say it is this pre-charge defendant more than anything else. I don't know that we're in a position at this particular point in time to say that any pre-charge defendant that the legislators could come up with would be objectionable. Okay. We're not in a position at this stage.
Very well.
This pre-charge defendant, however.
Very well. And Madam Chair, might I just, with one other question. So, to be a little more specific, so in relation, let's say, for example, in relation to Section 5.6 of the proposed, of the bill, Section 5.6 A to E.
5.6, you said?
The commentary of the law school in relation to that section is that an examination of the factors at Section 5.6 A to E begs the question, how, by virtue of the provision stated, will the defendant's remand in custody enhance or expedite the constable's investigation? Or is the aim rationally connected to the restriction of his freedom? And the factors listed are discrete, not cumulative, and only one of them is a sufficient basis on which bail may be denied. Mm-hmm. And my question is this. Mm-hmm. If this provision were to be framed so as to give the deciding official a choice as one of the factors to be considered. Let's say instead of just listing them and not specifying whether they are cumulative or discrete, what if the legislation were to say, these are some of the factors that a deciding official, or a judge, can take into account in determining the application? Would that have satisfied the law school's position in relation to that legislation, to that section? I'm just trying to ascertain that.
Well, to be fair to the bill as it is, it does do that already. At G, 5.6G, it says the judge can take into consideration any other factor that the judge considers relevant. Yes? Mind you, it does say at the top, shall in determining the application take these into account, and then move to at G to say any other factors. So it's not exhaustive. The list here is not exhaustive. There are other reasons. The problem I'm saying with these ones here, the submission really is we don't see how those should go towards him not getting bail. Why is it he would be kept in custody on the basis here? Yes? As we understand it, usually if the person is arrested, it's because the officer is attempting to secure evidence to obtain it from questioning him, or any other such method that goes towards getting the evidence that requires him, a requirement of the officer doing that successfully, either the accused, the defendant is taken out of the way. Yes, but these here are stated. They don't go that far at all. When I read them, that's not what they are. That's not what they appear to be saying. They're just disparate factors that are just stated as grounds for denying him bail. And when we put the high, when we consider that we're talking about someone's liberty, yes, and that is the constitutional norm, then it seems rather difficult to accept that on any one of these, that a defendant, see, I'm calling an accused person because it clicks like he's one, yes, that he could possibly be denied bail.
Very well.
Ms. Kohler?
Yes, Madam Chair.
We want to thank you for the presentation.
You're most welcome, Madam.
We will go through and we will respond. I just kind of wonder whether your submissions in respect of what you are placing before the committee for consideration may be inconsistent with the proposals that you have made. Because if in one breath your proposal, your submission or the content is that as provided for, you see trouble, but at the same time you are saying what is contained in the submission at page 8. There are some matters which, for example, on just a quick read, you indicate that the...
But Madam Chair, if I may just respond, you have to remember, even when we take the position that they may be unconstitutional, it doesn't necessarily mean we're not the ones who decide, and certainly we don't have the power to legislate. So you can nonetheless go ahead and legislate, and then the court can make that determination. So we have to provide for both things. So we say, look, and that is why they're in the alternative. We say, look, this is a position. However, if that's not accepted in the alternative, here is perhaps something that can better what you have. So they're not inconsistent at all. They're considering both sides of the coin.
Right. We understand that. But of course, you know that we give due consideration to presentations. And a presentation which is of the view that a provision is unconstitutional is just a little troublesome to then turn around to say, we have raised it, but you go ahead and legislate because the power is not ours to legislate. That approach I find a little problematic, notwithstanding any latitude and generosity that you may be providing for. I'm just saying...
That's not what was being said. There's a misunderstanding on the chair's part, I'm afraid.
Please clarify for me.
As I've said, we're looking at both sides of the coin. Remember the position that we are in. Yes, we're making submissions, and we recognize that the submissions, any or all of them, may be rejected, any or all of them may be accepted. So it must be that in all fairness, that we look at all the arguments in the round, because we hold a position that it may be. And our language is not that it is going to be unconstitutional, because we don't have the power to make that determination. Our power is to say at this stage, our draft arguments on a draft bill, yes, are as they are.
No, the bill is not a draft bill. Sorry. It's a bill. It's not yet a law. It's not yet a law, right. But it's not a draft bill.
That's what I mean. Thank you. Thank you, Madam Chair. You're correct in that regard. You're correct in that regard.
Sure.
So it is really making provision for that and nothing else. All right?
Sure, there's a quick...
coming up to you. You want to interject?
There's a quick...
Yes.
I want to join my colleagues in congratulating the Madam Kohler for the presentation. But just want to ask, she has stimulated some things in my mind, and I really need to turn them over some more. I'd like to have some dialogue with her, just for some clarification. I wouldn't want to detain the committee.
Certainly. Okay. So just to indicate, and we will wrap after this because we have Jamaica for Justice. One of the disadvantages identified is that a person on pre-charge bail could spend years in custody. I would just invite your attention to clause 5(7). The law does specify the maximum time that such a person could be detained, and it doesn't go in the years at all. But we want to thank you so much for the presentation.
Anyway, I hear you, Madam Chair. I hear you.
Right.
I don't see it, but I hear you. I will look at it more closely.
Right.
Thank you.
We want to thank you so much for taking the time to prepare the presentation and also to make it to the committee. We will consider and we will indicate our position.
A pleasure, Madam Chair, and it's nice to interact with you in these settings, more so yours than mine, but it's a nice change.
But thank you, and thank you to the law school.
You're welcome, Madam Chair.
Yes. All right, we now move to the presentation from Jamaica for Justice.
Good afternoon, everyone. I trust we're doing well, and thank you so much. My name is Michael Jackson, the Executive Director for JFJ, and I'm joined by Jade Williams, our Policy and Advocacy Specialist, and Karen Brown, our Communications Officer. This submission again is being made on behalf of Jamaicans for Justice reviewing this bail bill that exists to repeal and replace the Bail Act. And again, we just want to thank the Joint Select Committee of Parliament for the opportunity for JFJ to make this presentation. I want to start out by saying that JFJ is very cognizant of the high levels of crime. We've spoken around several issues around this, so I think from the get-go we want to make that very clear. And we are quite sympathetic to the plight of what even the Joint Select Committee members and all members of the House face when you're putting forward these pieces of legislation. However, JFJ, let me be very clear, we did contemplate whether or not an entire repeal was necessary from the get-go of this Bail Act. And that's a position that the board asked me to indicate, because from our perspective, the Bail Act in its current format does make provision for dealing with some of the issues that we're facing. And we did question whether or not perhaps a review was needed to simply reaffirm the existing legal mandate where an accused must be released with the fewest conditions necessary to prevent them from absconding, reoffending, or interfering with the administration of justice or bringing the criminal justice system into disrepute. Now, our presentation at JFJ, it is guided by a human rights principle, as you can appreciate. And we start from the place of the International Covenant on Civil and Political Rights when we're making our recommendations. And clearly, we would have reviewed several aspects and provisions in the Constitution. Now, one of the discussions we're going to be having, I'm sure, is whether or not the Constitution perhaps contemplate some of the issues that or the provisions that we see in the bail bill. And we did make in our submission the point around Section 14(1) of the Constitution. From our perspective, however, we don't agree or we don't believe that view should be a narrow view of the Constitution, because our previous colleagues said it quite well. There are other things to consider, other constitutional rights to look at. The presumption of innocence, for example, the right to a fair and impartial hearing. The protection of the public obviously must be balanced with that of the accused. So I think we're clear on that. So we can't be looking at Section 14(1) in a narrow view because you have other constitutional rights certainly to consider. So you're talking about speedy resolution of issues when you're talking about somebody's right to liberty. Now, one of the things we pointed out that Section 4 of the current Act, that a person accused of an offense should normally be granted bail, except in circumstances specified in the legislation and certainly currently provided for in our Constitution. From JFJ's perspective, a respect of these rights is what separates a liberal democracy from a totalitarian one. And respectfully, I think we have to be very careful about the path that we're going, notwithstanding the high levels of crime. And again, we're not disregarding the circumstances in the country. We're sympathetic towards it, but it has to be a careful balance that is struck. And I don't want to quote Madam Chair, because she did indicate that that's the objective from her perspective. But it goes back to the point. We recognize rights are not absolute, but they are in fact subjected to reasonable limits, as can be demonstrably justified in a free and democratic society based on human dignity, equality, and freedom. Now, if it is that we're going to be passing this bail bill as it is, I think another point that the committee must consider, what is the capacity of the country? The criminal justice system, to be specific. So let's look at it. The reality is, and Madam Chair had in fact recognized this in an interview that she did, that these provisions are in fact subjected to abuse. And if that happens, how will that impact the courts that are currently on the strain? We have lockup, overcrowding, that plague our criminal justice system. And I want to pause and remind the Joint Select Committee of Agana Barnett. In 1992, he was one of 3 men who died after being held for about 2 days in a small cell with about 16 other people at the Constant Spring police station. We cannot ignore these realities when we are passing legislation. And my question to Parliament is, what measures will be put in place to prevent these recurrences? I think we have to ask ourselves this. In 2018, I believe the then Office of the Public Defender released a report that suggested that you had several persons at the Falmouth police station that faced this similar issue. So I think we have to be guided by some of these things. And again, while we appreciate that these anti-crime bills are being passed, we have to ask ourselves, what provisions are really being put in place to prevent these types of issues that plague our criminal justice system? Before I get into the recommendations, I can't help but pause to remind the Joint Select Committee again of 6 pieces of legislation that were tabled in Parliament in 2008, but they came in effect in 2010, and these are commonly viewed as the anti-crime bills. Now, the 2 specific legislation or acts to make mention to at the moment is an act to amend the Bail Act, an act to make interim provision in relation to the grant of bail in specified circumstances. Now, in 2010, what was considered wasn't pre-charge bail. What was considered at the time was pre-trial detention and giving the police some powers to grant or deny bail, and I stand corrected if my memory is off here, for specified offenses. Now, when you look at the 2010 an act to amend the Bail Act, the provisions that existed at the time was that bail shall be granted to certain scheduled offenses for a period of 60 days during which they can be brought before the courts at specific intervals. At the time, it was 7 days initially, and then 14 days thereafter, and it went up to 60 days, I believe. At the time, JFJ spoke again, because from our view, that was, 12 years ago, I think the Bail Act of 2010, as it was contemplated, would have seen police officers being given awesome powers for up to 60 days. My colleague previously made mention of the Nation and Right v. AG and DPP case. And that particular court ruling is instructive because we're all aware that one act was struck in its entirety and another one, most of the provisions then were struck. So if it is that that time it was pre-trial detention, we ask the question, what would the courts likely rule on pre-charge detention in this current format? Because one suggests that you had enough evidence to charge someone, and in this situation, you have not enough evidence to even sustain a charge. So I think we have to be looking at previous court rulings to be guided by how we're passing legislation. Now, I did say that JFJ's concern was whether or not the bill needed an entire repeal. And I want to make reference to page 40 of the bail bill, which contemplates the memorandum of objects and reason. Now, from our perspective, that reasoning, respectfully so, is in fact confusing. Additionally, we are concerned that this language is in the bill, and I note that some components of it is also in the Emergency Powers Act that was amended. It says, the existing act was enacted prior to the amendments to the Fundamental Rights and Freedoms provisions contained in Chapter 3 of the Constitution of Jamaica, and the need for provisions to address the circumstances peculiar to Jamaica. There are two concerns there. Firstly, and respectfully, we've heard comments made in the media, and we are concerned that there is a suggestion that aspects of the Constitution are seemingly an impediment to the crime-fighting efforts of the government. We are concerned about that because we don't believe that that should be in a particular bill that is being contemplated for passage from the Houses of Parliament. Secondly, when you talk about the circumstances peculiar to Jamaica, then we're making it very clear that this bill here is not risk management to ensure that a suspect shows up for court. It is not risk management to ensure that there is no interference with the justice system. It is not risk management to ensure that witnesses aren't intimidated. This seemingly suggests that it is a crime-fighting bill. And I want to make reference yet again to the Nation and Right ruling because it was very instructive. The court said that, basically, and I want to summarize the ruling here, but you have it in our presentation, that Parliament can contemplate laws for different reasons, but the courts must consider what is in the Constitution and not the good intention of Parliament. That Nation and Right Court ruling must be instructive for the parliamentarians. So yes, we have good intentions. We want to manage the crime, but we cannot legislate something because from the get-go, and it goes into the other points, when you have that as your foundation for this bill being developed, it suggests that certain provisions will come. Yes? So I hope we're following what we're saying here. So the first thing is what we're asking for is that a more appropriate reasoning should be in the memorandum of objects that really speaks to the purpose of the bill and not issues about the circumstances of Jamaica and suggesting again that the Constitution may be a challenge to how we're moving ahead. And by the way, when I say government, I want to be very clear. Government from our perspective and what we learn in school as a student of public policy is speaking to both the parliamentary opposition and the ruling party. I don't want anybody to think that our statements here is levied against any one party. So I trust that clarification is also very clear as I go through. One of the major issues as I move from the memorandum of reasoning as well is the fact that the entitlement to bail has been removed as a starting point of the bill. Now, if you look at the bail bill, I want to bring your attention that the entitlement to bail is basically subsumed under Section 6(1)(a). And my colleague previously said it well. If it is that it is subsumed under Section 6(1)(a), it suggests that the entitlement to bail is only rarely there for the person who is on post-charge bail. So the person who is on pre-charge bail, who has no evidence against them, who have not been charged, is at a disadvantage. So the structure of the bill is also important for us to consider. And I think it sets a stage and a respect to the Constitution to have the entitlement to bail as it is currently structured in the current Bail Act, very clearly starting out the point of this current bill. And one of the things that we see problematic with removing the entitlement to bail, if you look at the reading in the current Bail Act, I'm not sure if persons have it here, but it's Section 3. What it also does is to delineate the powers of a justice of the peace, of a police, and of the courts. And I think that very clarity is important from the get-go my colleague will be speaking about the deciding official and our suggestion that is removed from the bail bill, because sometimes when you're reading it, it does lead to some confusion as to the power and authority of a justice of the peace, of a police, and of the courts. So that is something that Ms. Williams will speak to. Now, just to move the presentation along, I want to get to the conversation about the grant of bail prior to charge, which is Section 5, and Madam Chair was quite correct that this would be the most problematic section as persons review the bail bill. Now, let me be very clear on JFJ's position, because my board instructed me to speak with clarity. In principle, JFJ opposes Section 5 of the bail bill that speaks to pre-charge bail. The organization's position is that its existence may very well be deemed unconstitutional, not only with the current provisions within it, but the fact that it will likely be abused by persons who are representing the state. And if it is that one's right to liberty is abused in the way that we have seen it, then we see that we may have certain constitutional challenges that may also cost taxpayers their money. That's one practicality we have to look at. And then secondly, there's no monetary compensation that can ever really assure someone who has not yet been charged, give them back their time, give them back what they have lost. I go to the conversation about the state of public emergency, where JFJ, we represented several persons, and we know them. Everton Douglas, detained for 465 days. There's no giving back persons those days. When a man misses the birth of his child, there's no giving back those days. When someone loses their house because they could not work, there's no giving back those days. Now, we all believe in this normative framework of family time, helping your child with homework. There's no giving back those days. So if we're contemplating a legislation, we have to look at the likely impact that it has on persons. So JFJ's position from the get-go is that we believe that Section 5 ought to be struck in its entirety. And the board gave me these words to use, and I will use them, and I hope there's no offense. But they believe that it is offensive to the Constitution to have Section 5 being contemplated as it is. Nevertheless, I want to point out the reasons for it. When we look at the Bail Act and we go to, let me start out here, and we go to Section 5, and that is subsection 4, I believe. Well, let me not look at the sections because you're speaking, but the first thing to note is that you have an initial 6 months to be considered by the Justice of the Peace and the police in granting or denying someone's bail. We are aware that if it is that this bail is to be extended prior to the expiration of the 6-month period, that Justice of the Peace or police must go before the courts. Now, the conditions that will be imposed by the police, for example, who is a deciding official, as my colleague before noted, you are asked to go to a police station, you're asked to report at a particular time, keeping in mind that there's nothing preventing the police from changing those times, changing those dates. Those things are an inconvenience to someone who has not yet been charged, because there is indication and implication that that person is a 9-to-5er, for example. So we have to be careful again. Now, given the likelihood that persons from low-income communities will be disproportionately affected by pre-charge bail, and I think we must recognize the social class issues in Jamaica, right? There are concerns that impositions of surety or bond conditions will have far-reaching conditions for them, or implications, my apologies. For example, a person who is financially constrained may not be able to take up bail, and we have seen in other jurisdictions where high bail fees, if you will, for lack of a better word, have been used as a little loophole to ensure that persons remain in custody. And I think my colleague before, and in our presentation, our submission, we did in fact mention whether or not there should be some guidance given what this new bail bill is contemplating around what the ceiling should be. And then when you look at it now, this person, where no charges have been proffered against them, may be in custody for up to 2 weeks before Section 11, subsection 3 kicks in, where a judge will be reviewing the bail conditions. So in other words, I don't have the financial resources to take up surety or bonds that have been levied against me. So I have to be in custody for 2 whole weeks before a judge reviews that bail decision, and that is under Section 11, subsection 3 of the bail bill that speaks to review of bail decisions. Now, in JFJ's opinion, imposing restrictions on the liberty of the person should constitutionally be reserved to the judiciary when there is just cause. And I remind persons again of the Nation and Right ruling that had police officers been given awesome powers for pretrial detention, and whether or not we want to continue to allow members of the executive, in this case here, the police and others, such powers. And we believe that that will cause further constitutional tension, as we have seen in the state of public emergency. So we believe that that is something that ought to be considered. No, I think generally we have seen where the conversation of bail, it has shifted across the globe, where the primary concern of ensuring that the accused or suspect does not abscond to a focus on preventing offending while on bail. But we believe that there must be greater burden on the state to present evidence that an individual is likely to commit an offense. And when I go into specific section, we're going to be talking about whether or not the threshold is high enough where there will be less abuse likely. Now, the minister is correct, and we agree, that in reference to Section 14.1, specifically subsection F of the Constitution, a narrow reading of it may allow preventive detention by way of pre-charge bail where it is reasonably necessary to prevent his committing an offense. Now, notably, we said that this is already provided for in the powers of arrest, which allow the police to detain or arrest someone on reasonable suspicion that they're about to commit an offense. But we note, however, that the threshold is very high in that regard. Well, that's the reason why we're here today, obviously contemplating a pre-charge bail. Now, in its current reading, the bail bill does insinuate that the police are not able to meet the standard, and therefore they do need a lower threshold, which in many cases may be arbitrary, in order to carry out their duties. And we note that the strength of an evidence is important as the government respects the rights of persons' rights to liberty, security, and life. Now, we note as well that though in principle, as I stated, we believe that the pre-charge bail provisions under Section 5 to be deleted, we tried to look at it in a balanced view. If it is not deleted, what will likely happen? So, for example, in other jurisdictions, we have seen wherein persons, detain persons, charge them, detain them, and then release them after. We don't want that abuse to happen either. And therefore, we say, let's see how best we can mitigate certain things. Let's see how best we can force through legislation, or to ensure rather that the police acts expeditiously, because this is one of the challenges we're having with pre-charge bail for extended period of time. Would it basically say to the police, you know, I have enough time to really push ahead with the investigation. Let me ease up a little bit. Let me just continue doing other things. How an extended period of time that can go up to 1 year may negatively impact the course of justice. So if we were to even say, let us contemplate the investigation process here, because I think we have to think practicality when we're looking at these things as well. how will it impact the investigation process from law enforcement? What other tools will we give them to move ahead with investigation in a speedy manner to ensure that justice is secured for victims? Now, we realize that perhaps some reference was made to the United Kingdom Bail Act and their Police and Crime Act of 2017, which does allow the police use of pre-charge bail. And JFJ, we read extensively on this. In the United Kingdom, pre-charge bail should not last longer than 28 days. And it allows an extension permissible under specific circumstances and with court oversight for up to 3 months. Now, we must also look at the challenges with the UK. The UK situation, and by the way, this is an amendment of what they had before. The UK is currently reviewing this particular provision that they have because it has been abused in the United Kingdom. So let us quote some statistics that we have seen. 50% of the police charge bail cases in the United Kingdom prior to the reform yielded no charge, even with the police charge bail conditions lasting up to 1 year. So I think we have to look at what has happened in other jurisdictions if we're contemplating this. 50% of those cases went nowhere. In the United Kingdom as well, we have seen where minority groups were targeted. They were the victims of this abuse. My question to the Joint Select Committee, what assurances are we giving to ensure that such abuse is not in the Jamaican landscape? Because taking something from a country is one thing. It sounds good on paper, but we also have to consider the negative implications that it has had even in their jurisdiction. So JFJ's recommendation, to get into specifics now, is that the power of the police and the justice of the peace currently articulated under Section 5 to impose conditions to be removed from its entirety. So, to put it simply, JFJ is saying if Parliament is going to continue with Section 5, we do not believe that the police and the justice of the peace ought to be involved in the granting of pre-charge bail. We believe that if the Joint Select Committee is going to continue with Section 5, that the powers and the authority should be limited to the courts. And with that said, we have several amendments that will be needed in that particular section. And then even when we look at the time, for example, we noted that as a concern. So one of the things we said, Section 5.1a would continue. I think that is 48 hours currently. And my colleague, she did the math, and Section 5.1c had another 48 hours before someone is brought before the courts. Now, if we're saying that Section 5 should be limited to the courts only, it means that Section 1c will then be removed fully from the bail bill. So we're contemplating the first 48 hours right now. I want to bring your attention to Section 5, subsection 2. The reality is that there is no time limit in that particular section. JFJ had in fact made a public statement that we believe that that particular subsection leaves room for the possibility of indefinite detention. Madam Chair did clarify
Which clause
earlier.
is that?
Sorry?
Which clause?
Section 5, subsection 2. So if you look at the reading of it, it says, in any case where a judge of the parish court denies bail to a defendant who is arrested or detained without being charged, the judge shall specify the period within which the defendant shall be brought back before a judge of the parish court for the question of bail to be considered or reconsidered. Therefore, obviously, the person is in custody. There is no time limit there. And that was the issue we had with that particular subsection. Now, if I'm to follow what Madam Chair said earlier, that one can make reference to subsection 7, about up to 1 year, it still means that you can have somebody in detention for up to 1 year who has not been charged for any crime whatsoever. That is problematic. It is. And I'm not sure if this is a precursor to the conversation that is happening about preventive detention, which I stated earlier that JFJ does not support. So what we're saying is a reasonable time must be included in subsection 2. And let me be very honest, as an organization, we struggled. What can we propose to the Joint Select Committee as a reasonable time? And Ms. Bailey can look at the fact that we submitted or resubmitted twice because of that very contemplation that we were having. But our final submission from our board is that if Parliament is going to retain Section 5, subsection 2 should not go beyond 48 hours. That is what we believe is reasonable for someone who has not been charged with anything. Anything outside of that, from our perspective, will be viewed as arbitrary. So, to clarify here, the recommendations that we have made to date: 1, no police or JP ought to be involved in the granting of pre-charge bail. And secondly, it should be 48 hours by the court for bail to be considered. And if bail is denied, then the court shall be mandated by this legislation to reconsider bail within another 48 hours. Now, and we made some specific things here wherein that reconsideration could be grant bail with conditions, grant bail without conditions, or the person shall be released unconditionally. So we close the gap with our recommendation as well. Now, one of the things we pointed out, we've heard certain recommendations, again, about preventive detention, and as we stated, that ought not to be. And detention has to be the last resort if it remains in its current format. Yes? Because if someone has not been charged with anything, it can't be that detention shouldn't even be contemplated, quite frankly. But if it is, the extended period of time cannot be. And therefore goes to the next point that JFJ is making, that the threshold has to be extremely high to mitigate the possibility of abuse. So when you go to subsection 6 of 5, I want you to look at some things that are there. And my colleague before did an excellent job, so I don't think everything needs to be repeated. Let us look at section 5, subsection 6D, the conduct of a defendant. I'm not sure what that means. Now, as somebody who has a strong voice, I don't know if my strong voice may be problematic for persons. Will that be a conduct of a defendant? I don't know. So from our view, and we looked at other jurisdictions, what can be used to strengthen that particular provision? And JFJ submits that the conduct of a defendant ought to be strengthened or broadened to review someone's person or that person's history, including their character, their physical and mental condition, and the likely impact of bail conditions on their job and finances, the length of their residence, community ties, drug abuse history, prior criminal and bail appearance on record. So in other words, you're raising the threshold to ensure that this person, even if you're contemplating bail, what impact will it have on them? Will it damage their finances? Do they have strong community ties? So some of those things we believe ought to be strengthened a little bit more in the bail bill. To continue, as I stated earlier, we note that under, and I want to bring your attention now to section 5, subsection 5, that states that the period of the defendant's release on bail may be extended for a further period of 6 months. So it's two sections, I should have said, actually. Subsection 4 for that first 6 months, and subsection 5 for that second 6 months. We do not agree with that. We believe that an absolute minimum, or maximum rather, ought to be 14 days for bail, because this is someone, yet again, who has not been charged. Sorry?
Could you repeat that section?
Section 5, subsection 4 and 5. So its current reading is saying that the police and justice of the peace can grant bail for up to 6 months. But prior to that 6-month expiration, a further 6 months can be granted by the courts. What JFJ's position is that for someone who has not been charged with a crime, that is too excessive. That may lead to arbitrary use of that power. So if you follow what we said earlier with the recommendation about only the courts being involved, it would then follow that this section would be merged. And in merging this section, what we're saying is that it ought not to be for more than 14 days for bail, for someone to be on bail condition. Because it goes back to the earlier point that I made when I started, that bail conditions will have far-reaching implications on persons' lives and livelihoods. And we think that must be considered by Parliament as they really review this particular legislation. Now, one of the things we recognize as well, based on our reading of the bail bill, is that there is no provision for appeal of pre-charge bail or detention. I want to bring your attention to section 12, if I'm correct. Jade, please help me out, because sometimes I'm speaking from memory. I think section 12 of the bail bill, which deals with the appeal process, what it says is this. If you could please go to subsection 1, 1A1. That really reads that a defendant concerned, in accordance with any applicable rules of court, can appeal to a judge of the Supreme Court in chambers in respect of a decision made by a judge of the parish court referred to in section 5, subsection 7. So in other words, the appeal that is possible for someone is only the condition of the bail, of pre-charge bail, not the actual bail itself, not the pre-charge detention at all. This is someone, again, who has not been charged. So the point we're making here is that if someone is placed on bail conditions or placed on bail, an entire 6 months possibly may pass before that person is able to appeal certain aspects of their bail. And the reason our reading of it is like that is because section 12.1 also makes reference to section 11. And I tell you, the bill was very difficult to read because we had to be going from section to section to make sense of certain things. And then when you go to section 11, it makes reference to the review of the bail. So in other words, you can have someone on bail for an entire 6-month period without the review of it. And that is problematic for us. So if that provision is there, then what we're asking perhaps is for greater clarity to provide it in the bail bill in terms of the appeal process of the entire bail and the appeal process for pre-charge detention. I hope we're following. I hope I didn't lose anyone with that appeal process at all. One of the challenges we had, and I stated it earlier, so I'm moving from pre-charge bail now. I won't give much more because there are other things that thematic areas we want to cover. Generally speaking, JFJ is very concerned about the negative switch from judicial grant of bail to police grant of bail for serious offenses. We raised strong objections to this. And as I stated earlier, I'm urging the Joint Select Committee to review the court ruling of Nation and Right. Remember, the police was granted power when it came to certain offenses. It may not be the exact circumstances, but certainly it is instructive about whether or not the bail bill in its current format could withstand a constitutional challenge. And let me explain what we're talking about here. I want you to go to Schedule 2, or second schedule, Part 1. That is page 29. Could Parliament allow me 1 second? My child seems to be having some challenges, please. My apologies, he called 4 times, and as a parent, we have to be careful. Yes, thank you. Now, I want you to go to second schedule, Part 1, that's page 29 of the bail bill. And I'm sorry you don't have the Bail Act now to make some comparisons. In the current Bail Act, the courts are given the power to grant bail for firearm-related offenses. So the Firearms Act, for example, was mentioned in the current Bail Act. I think under the Offenses Against the Persons Act, you had a particular section that speaks to shooting or attempting to shoot or wound with intent that was limited to the courts. Now, when you look at the current bail bill, that is removed. So in other words, the police now has the power to grant or deny bail for firearm legislation. These are serious offenses. Remember, now we just passed a piece of legislation that says what? 15 years mandatory minimum. Serious penalties affixed to it. And then, when you look at the other pieces of legislation mentioned under Part 1, yes, you have the Criminal Justice Suppression of Criminal Organization Act. That is what? Commonly the anti-gang legislation. But I want you to look at the sections that are not included for the court. You have sections that will now see the police being able to grant or deny bail for penalties up to 20 years. That is problematic. That is too awesome of a power to be given to the police officers. These are things, again, that has to be restricted to the powers of the courts. Because otherwise we're sending a very, very wrong signal about what state we're operating in. It's a wrong signal that is being sent. I looked at Guyana's bail bill. I think they tabled it in July of 2022, and they're contemplating it now before their parliament. And I just want us to pause and think about the fact that Guyana's bail bill, for example, is more similar to Jamaica's Bail Act that currently exists in terms of the powers of the police. So in other words, our Bail Act is something to be emulated in its current format. Yet we're contemplating really giving the police this awesome powers. And I want you to follow me now by the statistics of the very Jamaica Constabulary Force. If we're saying that 70% of crime in Jamaica is committed by gang-related offenses and gun-related crimes, that means that 70% of possible bail to be granted will be restricted, or the possibility of it being granted or denied by the police. I'm not sure if that is what we would want as parliamentarians. This is where it gets problematic for us now when we read the bail bill as well. The bail bill is very offense-focused. And I want to go back to the purpose of a bail bill. The bail bill, or any act, bail act rather, or bail generally, is intended to mitigate risk factors. Now, for example, we saw this alarming article in the Jamaica Observer today that someone absconded bail and will likely commit a crime. and we are alarmed by it. My question is, though, is that something that routinely happens, or are we alarmed by the headlines that perhaps we're putting ourselves in a position to be legislating something that there is no evidence? Well, nothing has been offered to say that this frequently occurs. And I think we have to be careful, because our position is that fear cannot be a driver for public policy. It must be guided by evidence. And I want to caution us on that. And the reason for this being a concern, when we say that the bail bill is reverse onus, or it has reverse onus test, what it does is to no longer contemplate whether or not this person can come before the courts and answer for their crime. What it now contemplates clearly are offenses that are firearm-related and gang-related. And it goes to the point that my colleague mentioned around murder and murder under Zozo. Why is that in the bail bill? I'm sorry. The current reading of the bail bill and even the Bail Act does allow the judge to contemplate all of these factors. Why do you need to specify it in the bail bill? Because if it is that who you associate with may very well likely cause you not to show up, bail will be denied. And I go back, what evidence is there to suggest that these things are a challenge? Now, is it or should it be the basis for any consideration whatsoever? Why is it in the bail bill? We can play around with language about shall or may. We can do that. But the fact that it is there is sending a signal from the legislator that the court should consider this issue specifically. Why can't it be that the courts continue to examine whether or not someone will likely cause harm, whether or not someone will likely offend, whether or not someone will likely pervert the course of justice? And I remind Parliament of two key things. And by the way, before I continue, let us look at section 7(3)J. There's another point about the bill being offense-focused. When we go to section 7(3)J, I'm trying to find that particular section. It does speak to the conversation about firearm being used in the commission of an offense. And two, that the defendant came into possession of the firearm unlawfully. Unintentionally or not, what the Parliament is doing here is basically saying that I am recommending that someone may possibly be denied bail on the basis of, well, it doesn't even give the strength of evidence to say that the firearm was actually used and so on. But the reality is that the use of a weapon in a crime cannot be basis enough to grant or deny bail, because the presumption of innocence is paramount. And we note in our submission that the section does not speak to the need to actually recover the firearm or the standard of evidence around it. So that is needed. I want to say that I'm urging the Joint Select Committee to remind themselves of two important court rulings, one of which you may not readily know, but I will advise on it. The recent Privy Council ruling in Trinidad is instructive, where the defendant had challenged the constitutionality of a bail provision that allowed the denial of bail when charged with murder. Again, we utilize may or shall, but we question whether or not murder or zozo should be included. Then lastly, we may mention to a case in Ghana where the person there challenged the courts because their reading of the Bail Act specified that bail can be denied for felony offenses such as rape, treason, robbery, subversion, and so on. Very offense-driven. And our fear, if this bail bill passes as is, will it be struck down on constitutional basis? This is something for the Parliament to consider. I will allow Jade, please, if you would allow me, to speak to an important issue. Just 5 more minutes. I know you said 3, but I would ask you for 5 just to wrap up, and for Jade to focus on the issue of our children in the bail bill.
Thank you to the committee for allowing me to speak. So I would in the interest of time, I would guide you to recommendation 5.2 in our submissions, or written submissions that we would have presented. And that recommendation is speaking to the way how children are treated under the bail bill, with also concerns with the Child Care and Protection Act, which is where the majority of provisions related to bail for children is treated. And we noted some specific issues with the construction of how bail is treated across both acts. So firstly, the Bail Act, both versions, the current bill and the previous act, reference the Child Care and Protection Act in terms of how children are to be treated. So we have to look to those provisions. And when we do look to those provisions, we've identified some issues under Section 67 of the Child Care and Protection Act. So firstly, we're unclear of what the agency of care and protection is, as there are 2 identified under the Child Care and Protection Act. So it is unclear as to whether or not it is the CPSFA or the Children's Advocate that would be leading on issues to do with children in conflict with the law, particularly to do with bail. The Act does not specify in relation to bail that children are to be treated in what is the best interest of the child. That is not specified in relation to bail in particular under the Child Care and Protection Act. Another issue that we would have identified is that where bail is denied, the constable is simply to communicate this to the agency of care and protection, and then the child is to be remanded. Concerningly for that as well is that the child can be remanded legally under the Child Care and Protection Act into an adult facility. And if we are considering the provisions under Section 5 of the bill, then we have to raise serious concern about children being included in those pre-charge provisions as well, and what that might mean for their detention, and what that might also mean for their ability to be released from detention. So we pointed in our submission to New Zealand's provisions in relation to children, and we found that it was instructive, whereas they directed the specific agency responsible for care and protection of children, and that the child is remanded into their custody and placed into a non-penal housing until the child is brought back before the court. So we recommended, as I said in recommendation 5.2, that this is something that we possibly replicate. We ask that children be dealt with specifically under the Bail Act, and we ask that the Child Care and Protection Act be amended to include the best interest of the child in the consideration of bail. We also made a recommendation as to what a section under the Bail Act could look like when dealing with children, and we specified one, that we should join the responsibility of the agencies, the Children's Advocate and the CPFSA, due to what we consider to be resource constraints to deal with children in these situations, firstly. Secondly, we ask that their remand be to one of these agencies and not to a remand center, or due to the possibility that this could be an adult facility under the provisions of the Child Care and Protection Act. We also asked that there is a psychological evaluation done when a child is in conflict with the law, particularly where they would have been placed on bail. And we also asked that there is a specificity that it is dealt with in the best interest of the child. So that is our submission in relation to children.
Thank you so much to the committee members. I just want to close out by saying, from our perspective, we cannot have a bail bill being passed wherein it's basically serving as a proxy for guilt and punishment. The bail bill has to focus on what it is intended to do in terms of ensuring that the course of justice is not perverted, because presumption of innocence is key. All right, thank you so much to the committee.
Thank you, JFJ, for your presentation. I invite comments or questions from members.
So I find it very
Member Jackson.
Thank you. I find the presentation very, very interesting and some critical points to be considered. One particular question, Miss, oh, by the way, you have a good name. In section 5.2, where we were discussing about the denial of bail, and you had proposed about the 48
hours.
Right. Where bail is denied, what are your thoughts regarding reasons for denial being, there's an initial period of denial and then another period for bail to be considered further?
Yes, that's what it's contemplating
right.
now, and we're saying it should be restricted.
Yes. Well, what are your thoughts about if the reasons given for the denial of the bail in the first instance, in other words, some grave situation that has been brought to the fore, could that influence the time frame for the second come around for the bail? You had suggested 48 hours.
So we're suggested 48 hours first and then 48 hours. So there are two 48 hours that we're suggesting only.
I was thinking if the circumstances circumstances could justify or give support to a longer period than the 48 hours initially.
You know what JFJ considers around preventive detention, which is basically what we're speaking about here, is the possibility of arbitrary use and the likely cost that it will be to the government and the individuals. I heard my colleague earlier talking about ease of civil remedies. We don't have that. I think persons must do what? Go and apply to the courts, and then if the court is so inclined, then we can't. Draconian laws, and I'm sorry, that's what some of these things may very well be, which may lead to abuse, must consider how we're going to be providing remedies to persons if they're harmed. And from our perspective, why not focus on strengthening the capacity of the Jamaica Constabulary Force to ensure that they're able to bring forward charges? Because if we're very concerned about these grave offenses, as you call them, because remember now we say 48 hours, 48, and then you can be released on bail conditions thereafter for what we're proposing to be a 14-day period. If you can't put forward a charge in that time, then the capacity of the officers, we have to question that. We have to question that. So remember I stated earlier, when we have an extended period of time, the question is, does it undermine the officer's ability to move expeditiously? What would be the negative impact of that? I know Jade wanted to add to a point based on the question you asked.
Yes, I just wanted to point to a general recommendation that we would have made under, I think it is recommendation 8.1, where we ask for there to actually be a burden on the state to act expeditiously. Because what we wouldn't want, especially as we're dealing with pre-charge detention, and I think we have to really think about the fact that this is a person that may never ever be charged, and how long we can impose conditions on a person that may not even reach the threshold to be considered for charge. So when we look at that, there has to be a specific burden on the state, especially with the resources that the state has to act quickly in these matters, an additional burden where we're dealing with pre-charge detention or bail.
And to remind you, Member Jackson, OPD report again, over 10,000 persons detained on the SOE in 2018, only 5% were ever charged. And if I Exactly. And if you remember, I think the leader of opposition actually quoted some statistics the other day in his presentation that said that 325 persons were charged to date. Not charged. Why do I keep saying charged? Because that's what we should really be discussing and not pre-charge detention. But the leader of the opposition articulated that 325 persons were detained under the SOE that just expired. And I think his presentation indicated that 85% of them were released. So I go back, even one day of detention can have far-reaching implications for people. Pardon? So, but the question is, what real... But that's the point that we're making in our presentation. How do you ensure that the investigation is strong enough, the intelligence is good enough to likely be converted to charge? I think these are the things that you must consider respectfully.
Is there, Member Williams, you have a question, comment? No? All right. Is there any hand raised from the online forum? May I just ask you, Ms. Jackson, from
Yes.
your reading of the pre-charge provision, what is the goal that the law is seeking to achieve on a reading of the law there?
Well, I started my presentation with the memorandum of objects, and to be very honest,
No, the
we are
provision
unclear.
in respect of pre-charge bail.
Yes.
What, from your reading of it, what does it seem to be going after?
If I'm to say the purpose and of this pre-charge bail and by extension pre-charge detention, it is to allow for investigation to occur for persons who are seemingly involved in grave offenses. I think that's what the Joint Select Committee and by extension Parliament is trying to achieve. If I answered your question, that is my understanding of it.
So it provides, well, we can actually read it. So we can read it. Where on reasonable grounds that a defendant has committed an offense listed in Part 1 or 2 of the second schedule and punishable with imprisonment, the defendant is arrested or detained but has not yet been charged because more time is needed in order to prefer charges. The question of bail shall, within a time, be considered. So, in your presentation, so from where JFJ is monitoring, do you see it necessary for time to be allowed for an investigation to be completed with a view to bringing charges where there is reasonable grounds for believing that someone has committed an offense?
Remember, I started
All
the presentation from the get-go by saying that JFJ believes that the current form of the bail bill ought to be struck. However, in trying to answering your question, though, we did put forward some recommendation that would allow that very same process to be followed. It's just that our recommendation is saying that the first 48 hours for bail to be considered or granted or denied to be done by the courts, and then the court will then have another 48 hours to review that decision. And then secondly, if bail is in fact granted, it ought not to exceed for 14 days. So I think that is what we proposed as something that may be reasonable, where the courts may very well not deem this unconstitutional based on our understanding. So we did meet you some ways.
Yeah, no, I'm just seeking to understand. We will have to consider the presentation. So JFJ accepts that there is a high level of crime in Jamaica.
Absolutely.
And serious crime. No dispute on that. And you accept that where there is reason to believe that someone has committed an offense, time will be required for an investigation to be concluded with the goal of charging the person for the offense for which you've suspected that they have been committed. We're just talking in principle now.
Sure.
Are we in agreement on that?
Madam Chair, one thing I hardly do is to answer leading questions.
To answer?
Leading questions.
No. I'm looking at your... I don't know that it is a leading question.
I prefer for an open question and then I answer. From our perspective, we understand that the crime rate is high. And we understand that Parliament will be passing legislation to deal with it. Our perspective, however, is that those pieces of legislation must be reasonable and they must be done based on the existing constitution where the charter was just passed in 2011. That is our perspective.
All right. Just trying to reason out your submission. All the submissions will be properly considered. Right. We're just talking about the goals of justice now. So, offenses where there is suspicion of offense, that time is required to investigate. And depending on the complexity, depending on how many persons are reasonably believed to be involved, it will take time. Depending on exhibits, some of them may have to be forensically tested. You have to get witnesses who will have to give statements, etc. It doesn't happen overnight. Reasonable? Is it reasonable to say that we do not move from arrest and detention to trial just like that? There are steps in between.
Yes.
Right. So you suspect that someone has committed an offense. You have to find out what are the grounds for reasonably suspecting that the person has committed the offense. And then there are a number of things that would have to happen between that time and trial.
Yes.
Numerous steps. And it takes time. We agree with that in principle.
Well, there's one thing I would want us to be very clear on, that there is the difference between pre-charge detention and bail and pre-trial detention. And the step of the way that you articulated would have clearly said that.
Right.
And the current law does provide for pre-trial detention, yes? So from our perspective, what we're seeing is our proposed timeline, and keeping in mind this is something from a principled perspective we don't agree with, but we're trying to ensure that Parliament gets a perspective that is very human rights focused. And we think that 48 possible pre-charge detention.
We don't come to the timing yet. I mean, your proposal is set out. I just want to reason in principle, so that is it your understanding of the Jamaica constitutional arrangement that where someone is arrested or detained on reasonable suspicion that they have committed an offense, then you must consider what you do with that person?
Yes.
Right. And the options could be, do you keep them in custody or do you release them on conditions or without conditions? Do you understand that as part of the constitutional arrangement?
As part of statutory law?
No, constitutionally I'm speaking. Constitutionally,
I'm
at the highest level.
Because the Constitution allows for other rights to be contemplated, which I articulated before, right to due process, right to a fair hearing. And I'm saying statutory law will analyze those constitutional provisions and put certain timelines in place. So I think for a JFJ perspective, it's the time frame and all of those key rights that will inform our decision or discussion.
I'm not merely asking for a restatement of the submission that you're making. We're trying to understand the perspective.
And I'm answering you, Madam Chair. I'm answering.
I think you're answering in a predetermined way without, it appears to me. But let's just say, is it your understanding of the constitutional law of Jamaica that where a law engages a right, then the starting point is for the court to ascertain what is the justification? What is the goal that you're seeking to achieve as a starting point?
Well, we quoted in the Nation and Rights
some
case.
of the case law call a justification justificatory criterion.
Well, we quoted the Nation and Right case where the court indicated that they will not be looking at the justification or the thought process of Parliament. They will be looking at the constitutional provisions. We had, in fact, quoted a particular section of that ruling in our submission.
Nation was decided before the Charter of Fundamental Rights and Freedom changed. Chapter 3 changed.
Yes,
right.
And my question is, though...
No, we're just saying, so
yes,
Nation,
I'm aware, yes.
The Adrian Nation case was decided on the old Chapter 3,
yes,
not the Charter of Fundamental Rights and Freedom. You accept that as a matter of fact?
Absolutely, that's a statement of fact.
Are you of the view that the provision on which Nation was decided is a different provision that one is contained in the current Charter of Fundamental Rights and Freedom? It's a yes or no.
I will say this.
It's a yes or no. Are you saying it is the same provision,
Madam
or
Chair,
you can't say?
respectfully, I cannot be put in a corner.
No, it's not a corner.
In accordance of how you want to
It's not a trick question. I'm merely asking whether, because it's a matter of looking at it, you know. It's a matter of fact. It's a yes or no. Is it the same constitutional provision?
I think we can respectfully agree to disagree whether it's a yes or no. Excuse me? Yes.
Case of Adrian Nation was decided on the old Chapter 3. No dispute about that. But no. even if you were to take another view, it wouldn't change the facts because the record
about the
is there
date
to show.
Of the decision. No.
And also, the provision in the old Chapter 3 can be compared. It's a matter of record. So, whatever your view is
it's
on
a level of comparison, Madam Chair, that will be instructive.
Right.
Yes.
Right. Now, you raised some questions about your discomfort with peculiarities in the Jamaican situation. Do you accept that there is a culture of intimidation in respect of witnesses that has raised concern in the wider criminal justice system?
Absolutely, and we've called for the witness protection to be given greater resources, and we've called for community policing to continue to build that trust within the community so witnesses can come forward.
And are you of the view that it is a reality in Jamaica that we have had a problem with persons being detained in custody who have not been charged, and the issue of bail has not been considered in the way that it should be considered for those persons?
Yes.
That we have had problems around
Absolutely.
Persons in custody. Yes. You want to jump in, Member Jackson? I'm just reasoning with the JFJ, you know.
Oh,
sure.
no,
yes.
don't let me disrupt the reasoning then.
Just out of interest, Madam Chair, I just wanted to understand, is the AG's chamber represented in our sittings? Because there are some very important issues raised.
Yes.
I believe that the AG's chambers.
Absolutely.
But I haven't seen anybody.
Yes, I see Mr. Foreman is online.
Oh, okay.
Well, I think I can say that all of the issues raised, we will respond. I think the ministry will have to respond in terms of helping to guide the committee with the concerns that have been raised. But just to say that all of the issues raised in respect of the efforts, the previous attempts in 2010 to amend the Bail Act, the striking down, all of those matters were considered. The case of Nation was considered. The chambers did opine on the provision, and in keeping with the procedure before the legislation committee, the chambers was a part of the deliberations and offered comments along the way. Yes. So the comments, the submissions from both the law school will require a response, I think, to put before the committee. And I see that we have received submission from the Bar Association. They were not able to come So we will have to discuss in earnest and respond to the points raised. I think if I were to sum up my understanding of JFJ's position, particularly in respect of the pre-charge bail, is that it opposes it because of the likelihood of abuse.
Yes.
You find it offensive to the Constitution.
Yes.
Your preference is, your recommendation is that for it to be taken out, but if it is retained, you would want the power to grant pre-charge bail be given only to the court.
Yes.
You raised an issue in respect of the schedule on the firearms. There seems to be a little printing mishap as conferring with the CPC in respect of drafts. So what
but
is
to
contained?
clarify, Madam Chair, it's the firearms,
yes,
the Offense Against the Persons
yes.
Act.
Actually, there seemed to be an omission in that schedule.
And several sections of the anti-gang legislation.
If you notice, at Part 2, those matters are set out there, but they seem to be omitted from Part 1. It's a printing issue.
Okay.
So
that's good to know.
Yes. Thank you for bringing
we
it.
picked that up at 2 a.m. in the morning when we were reviewing.
We kind of checked that. But very interesting perspective being shared on this important matter. Very interesting views on the understanding of what is constitutional and what isn't, and the kind of analysis that we will have to embark on.
Please. And may I made mention to the Ghana case. May I get permission to send that to Ms. Bailey for reading? It's not in the submission, but it was in my presentation.
Be assured, the public can be assured that the provisions contained in the bill did not spring overnight at all. They did not. And you can be assured that all of the constitutional material and the opinions of the court and the cases were taken into consideration in developing the policy. Be assured that the debate raged internally. It did take some time before the bill came to the Parliament. No issue raised so far has taken us by surprise, and we will respond in due course for the committee's consideration as the line ministry with responsibility for the bill. No issue raised has taken us by surprise at all. Not one single issue. Some important suggestions have been made, and when we come to deliberate, we will consider. I must say that it's interesting to hear the views on the readability of the law and the ease or difficulty with which persons go through it. That's a perspective that we always have to consider. We are of the view that a lot of the questions raised are, in fact, answered in the law. And it is my hope that you will stay tuned when we come to responding and or deliberations. We really want to thank you for taking the time to respond and to make the submission. Member Jackson, you wanted to come in? Yes.
Pardon?
Yes.
Yes, we'll do.
Yes.
Thank you.
I really just wanted to make the comment, Chair, with the discussion regarding the reason for detention is to carry out further investigations and to avoid intimidation of witnesses, etc. The difficulty I have with that, Madam Chair, that cannot be the reason, because we have persons who have convicted and in prison, and we are not stopping them from intimidating or giving instructions to people who are out there on the street. That is a matter of fact. They are in the prisons, and we have not been able to prevent them from stopping witnesses or committing other crimes. I remember a couple of years ago, the JCF advised one particular individual who is convicted on a 30-year sentence was responsible for up to 70 murders in the custody of the state. So I raise that because I don't take any comfort from the fact that if you lock them up, you can then carry out those things. That's one. The next point I wanted to comment on, to you, Ms. Jackson, what is your views on the granting of bail with strong restrictions? Restrictions, for example, the ankle bracelet, restricting them to specific location. Because for me, I feel very strongly about innocent persons being denied their freedom. I feel very, very strongly about that.
Jackson.
No, one second, I'm finishing now. I'm commenting on this whole thing about investigation with the detention when you haven't even been able to charge them because you don't have enough facts or information. We ought to consider coming out with a win-win. Seek to protect, if there's a perception or there are reasons to believe that the persons or the public is a threat, to protect that interest of the public while at the same time, in the context of not establishing guilt, to preserve the freedom of that presumed innocent person. So if you lock them up in them house, restrict them to them house, very little them can do outside of there because you don't find them guilty yet. That for me is something I'm quite disposed to, if there's strong reason to impose those kind of restrictions. But to lock up somebody in a cell when we don't certain about them have overwhelming reason that they are guilty of the offense, that one is turned me. It can be me. I know many innocent people get fall in that situation, and to my colleague over there, no compensation, no monetary compensation.
I'm happy your mind is there, Member Jackson, because that is our concern, that it has to be based on the strength of the intelligence and the likelihood of it being converted to evidence and then charged thereafter. And that is something we did put forward in our submission, because at least less rights and freedoms may be affected. And I'm happy that you raised the conversation, Member, about the matter of compensation, because mistakes will be made. And if they are made, I don't believe that we should subject innocent persons to a court process that will further put them at a disadvantage. So just as though we had the conversation here respectfully about whether or not if we remove a gag clause, if we are open to defamation and so on, it has to be the same conversation being had. If we put forward these legislation, what is the state willing to pay for people? Basically, you need to put JFJ out of business. I need to be out of a job because the human rights is good. And the last thing I want to put forward to Madam Chair, when we have these types of laws being passed, we believe that a strong human rights institution for horizontal accountability is important. So I could not leave this room without calling for the establishment of the National Human Rights Institute. It is very important based on this. And I see Madam Chair smiling because you know where JFJ's position on the NHRI is.
Just to wrap up the comments, because we are going to be taking the adjournment shortly. All right? We know that people are tuned in, and we haven't come to deliberating. We really are taking the comments. But let's just be clear that the pre-charge provision of the bill speaks to what do you do when someone is arrested or detained on reasonable suspicion that they have committed an offense. Not that they're arbitrarily detained, not that they're whimsically detained. The very standard that is set out constitutionally, what do you do with them? And the provision says that you must consider the question of bail within a period of 48 hours after the arrest or detention. All right? And that the bail may be considered by the justice of the peace, a constable, at or above the rank of superintendent, who is neither the investigating officer nor the arresting officer. That is what is provided for. It says that after considering the matters specified, matters which are specified, the official may grant bail to the defendant or may refuse bail. All right? What do you take into consideration? Says the law. The grounds on which it is alleged that there is reason to believe that the defendant has committed an offense up front is their substance. Absolutely nothing arbitrary. What is the stage of investigation so far? And the manner in which the investigation has been conducted. So it's not an officer come to say, boy, may I do it? And remember, this determination is not being made by the same officer who is involved in the investigation. It has to be presented to a superior officer or a justice of the peace. Then it says that you have to consider whether further time would enable a charge to be preferred against the defendant, the conduct of the defendant. You've raised question as to what it means, but it is left as broad so that anything favorable or otherwise can be taken into account. The reason given as to why the defendant has not yet been charged, all of these matters have to be taken into account. So, for the listening public, it's important that we put out what is provided for, because the impression that is being given and the concerns, genuine as they may be, may not have taken into consideration what is provided for.
But to clarify, Madam Chair.
Hold on. It says that when bail is not granted, so upfront, when bail is not granted outside of court, then you have to bring the person before the court for the question of bail to be determined. And then it becomes a matter for the court to decide, having assessed all of what the law says it must take into consideration. And I don't know who is best placed to determine wherein lies the interest of justice, of whether on reasonable suspicion that someone has committed a serious offense. It's not just any offense, because it speaks to offense listed in parts 1 and 2 of the second schedule, and also offenses punishable with imprisonment. So it already tells you that we're talking about serious, specified offense, not offenses at large. And then it sets out a scheme for dealing with it. Now, if the concern is about people languishing in custody, and this law is saying that if you have reason to take them in, but you need more time, then this is how you have to treat them. I just kind of wonder if it's the same provision that we're talking about.
I think my question to you is twofold. All of those things that you mentioned, respectfully so, what does stage of investigation means? What is the weight of the evidence that you're asking of police? I mean, let's not kid ourselves 1 second here. An investigative officer, though they are excluded, it is still a member of the JCF. And my question again, it goes back to the concern. Bail is currently
granted by the police.
But I go back to the concern,
though.
Current
scheme is that bail is granted out of court and bail is granted by the court. Bail granted out of court is done by the police or the justice of the peace.
By law offenses currently, per after charge, per the current Bail Act. And I think my question, though, respectfully so, what evidence do we have that the current Bail Act is not working? Forget the media headlines now. What evidence, credible evidence, has been put forward that the current Bail Act is not working? And I think my question again is, should we be legislating the removal of the judiciary? Well, I think you answered earlier that the offenses were a printed,
come on.
a printing error.
No. There is no exclusion of the judiciary currently. Hold on.
But I want to clarify based on the current
People
bail
are
bill.
listening, and it's important that there be accuracy.
Yes.
The law provides for the grant of bail at 3 stages: pre-charge, upon charge, and post-conviction.
But we are talking about pre-charge,
Hold on. Accuracy matters. You have said a number of things, really, but because we're not going into the deliberations at this time, it is not correct to say that the entitlement to bail has been removed. It is not correct. It is expressly stated at Clause 6 of the Act.
For post-charge bail.
Exclusively stated. I don't know whether you believe the use of the word shall, whatever your take on it, but it is interpreted in law. I want to thank you for the presentation.
Thank you, Madam Chair. We can agree to disagree on certain things. Yes.
The JFJ, we welcome, the views presented. As I've said, I will conclude by saying that the law has to be read fully and carefully, and the submissions made will be considered by the committee at large, and the committee will have a response. But I do not want anyone to go away with the impression that in this bill, in respect of pre-charge, the question of bail before charge is to be determined. If, on consideration of what is to be balanced, the decision is taken to remand the person in custody, time frame is set, safeguards are in place, and we will speak to that when we go into deliberation. So for those who are listening, I invite you to read the bill. It is available, and I invite you to continue to stay tuned, because what is presented today is not the end of the matter. Responses will have to be made and deliberations will be done, and they will be done against the intention of the provisions clause by clause. Is there any comment, any question before we move to the next? This brings to an end the presentation, and like I say, I thank you and I thank the law school for taking the time.
Madam Chair, and that's a good note on which to end.
It is on which to end. It's such a learning for me as I come into the Parliament every day, coming from the background of having spent time as a prosecutor, having spent almost a decade on the bench as a judge. I have seen the criminal justice system from many different angles, and now as a lawmaker. And I think we all come with an interest in building a better Jamaica. But we do have different perspectives on it. Very, very interesting. And this is why a forum like this of exchange in perspective is really important. I learn a lot every time we sit like this. I learn a whole lot. So, the next item on the agenda is any other business. Is there any other business? So there be no other business. The date of the next meeting will be Tuesday of next week. It's in the a.m. at 10 a.m. And my closing remarks would be that I can see that we're in for an interesting
I'm sorry to interrupt your closing remarks. I just want to be clear that because there are some very important issues that have been raised, constitutional issues, so I really want to know that the AG's chambers is going to is involved and is going to respond in similar detail as we have gotten today.
That is usually how it is done. The issues, the constitutional issues that are raised are responded to. And I think we will share a little more of the policy considerations. And at some point, since comments have been made about the drafting, I know the CPC can also assist us along the way. But what is clear to me is that some of the issues raised are answered in the law, but it does appear, it makes me wonder whether the entire bill has been read fully and carefully. All right. Anything from Madam CPC?
Thanks, Chairman. I would just like to add, it also makes me wonder if the existing act was read, because when I heard the discussion about pre-charge bail as if it was something entirely new, I had to wonder if people actually read the existing Section 22 as well as the definition of bail in criminal proceedings, because that does refer to bail that may be granted to a person who has been arrested but who has not yet been charged.
Because I sit in the chair, I'm trying to temper my comments, but the two submissions really raise a lot of questions for me. And at this time, I can only go away from this sitting to read the submissions again against the law. I've always said that in discussing the law, my approach is not to talk about the law, but to look at what is actually provided for. Madam CPC, I do share your view that I'm a little lost. I'm a little shocked, as it were, in light of what is provided for in the current law and what is being proposed here, whether there is full reading.
Madam Chairman, for those of us who are not lawyers, for the members of the committee who are not lawyers, might it not have been useful that the CPC could have started, or you would have allowed the CPC to start with an overview of the scheme and explain where we're coming from with the old law and what has changed with the new law? That would have been very helpful if the whole context was established. And I'm not talking about those who may have made presentations who are lawyers, but certainly for the members of the committee who are not lawyers, that would have been very useful. And even for those who are lawyers, but it would have been useful to help remind them and understand the whole structure of the new bill and what it was remedying and what were the shortcomings of the old bill.
Noted, Member Bunting. Madam CPC?
It's not usually the CPC's job, it's usually the ministry's job to give the overview, but I thought I had seen that somewhere. It was on the agenda. I think after the presentations, it would have followed.
I too, Madam Chair, I came expecting that overview.
Right,
presentation.
Normally the presentations are received, and then before we go to deliberation, we would do that. But
because I think the context,
yes,
would be better to assist us.
Yes.
In even appreciating more the presentation.
All right. So perhaps we would rearrange the next sitting, the Tuesday sitting, and deal with that, and then we would resume the presentation on Wednesday's sitting.
To see how we transition from the old to the new.
Yes. But it is, as the CPC indicated, it does raise the question as to whether the current bail law has been read and whether the bill has also been read in full. Yes. All right. Yes. 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 I'm just amazed that it could be said that the entitlement to bail has been taken away when it is expressly provided for. I'm just a little amazed, and it makes me wonder whether we're reading the same bill. It's expressly provided for. So I don't know how something can be expressly provided for, and it is said that it has been taken away. All right. Yes, quite interesting. Quite interesting. All right, so next Tuesday at 10 a.m. Tuesday is the 6th, is the date and time of our next sitting. Will someone move for the adjournment? Member Williams, Member Charles, will someone move for the adjournment? Moved by Member Charles, seconded by Member Williams. Meeting is adjourned.
Every Jamaican has the right to know what is happening in Parliament, to know when new laws are being passed, and to give their opinions on legislation before either house.
Every Jamaican has the right to see their representatives in action, making laws, holding the executive to account, representing the people, working for the benefit of all Jamaicans.
It is your right to observe first-hand meetings of the Senate, meetings of the House of Representatives, and the meetings of parliamentary committees. You may also take a tour of your parliament.
To find out more about the Houses of Parliament, please call 876-922-0200, follow us on Instagram and Facebook, or visit our website at www.japarliament.gov.jm.
Welcome to the final presentation on banqueting server. This is another episode in the Heart NSTA Trust lecture series, The Heartbeat. I'm your host, Kevin Baxter. For this session, Mrs. Sims Reed and Miss Campbell will guide you through 1. Providing table service for food and beverages, 2. Discussing the different types of meal courses, and 3. Demonstrating various napkin folds. Here are Melissa Sims-Reed and Lloydette Campbell.
Now we're on to our final unit. Provide table service of food and beverage. Now when you are ready to provide table service of food and beverage, you have to ensure that you do your mise en place. Now mise en place, this is the pre-preparation before service, and is done to ensure that all equipment is checked and prepared. Tables. Now the size of the table should accommodate the number of persons to be seated. They must be clean and in working order. So you check to ensure that the table is sturdy, and if you are using a mixture of round and square tables, then you would want to ensure that they blend in well. Chairs, they must not have rough edges, and they must be placed between the legs of the table. Glasswares. They should be highly polished and arranged neatly to the right of each cover. Now, when we say polished, this simply means ensuring that the glass has a high luster, a sheen to it. And this is done by placing the glass over hot water, using a piece of cloth to rub until you achieve your desired luster. Silverwares, they must be polished and set neatly on the table. Flatwares must be crack-free and placed appropriately for service. Now, what is a place setting? Now, this is the term that is used to describe a cover that is set for an individual on the table, and this is usually used for a formal dinner. It consists of all the tablewares usually found at the table, such as your cutleries, dinnerware, and glassware, and they can be small or large depending on the meal. Now, what is a course? A course is considered a single food item or a set of food items served at once, such as a cream of pumpkin soup garnished with croutons, or baked chicken, mashed potatoes, and grilled vegetables. An average meal consists of 1 or more meals. Now, there are different types of courses, but today I'll be focusing on 5 courses, as we will be demonstrating how to set the table for a 5-course meal. And our 5 courses include appetizer, soup, salad, entree, and dessert. Table setting includes setting for breakfast, lunch, dinner, special occasions, cocktails, buffet, brunch, or weddings. Now, regardless of